Good morning. Please be seated. Demand your chairs. Mr. Switek.
Your Honor, after Mr. Twice's case, can I approach real quick?
Yes, sir.
Yeah, you may want to do that now.
Okay. May I approach, Your Honor?
Granted. Go ahead, Mr. Switek.
Yes, sir, thank you. Your Honor, this is Fay Volz in 23 CF 1491. We filed a petition for an expungement, and the court ordered a hearing on it for
Right.
today.
Does the state intend to traverse or demur the petition?
We do not, Judge. We reviewed the case and would concede that Ms. Voles qualifies. The victim's parents were given notice their last known emails on April 8th, and we did not receive a response from them, but they were notified in accordance with the constitutional amendment known as Marcy's Law.
All right, have you submitted an order, Mr. Switek?
Yes, I have. I also have a paper copy if the court would like it.
Yes, would you please? All right.
Thank you, Your Honor.
Thank you. Anything else today, Mr. Switek?
Yeah, I've got two more cases, Your Honor.
All right, go ahead, sir.
Yeah, you're done. I call Lyle Rubens next. It's 22 CF 2311. He's an inmate. Your Honor, this is Lyle Rubens, and he has been discharged from Florida State Hospital on, I believe, February the 27th. And they have submitted a report to everyone. I'm sorry, he was discharged on the 10th of March. They found him competent on February 27th. I've met with Mr. Rubens at the jail. I found him competent to proceed. I met with Mr. Rubens this morning. I do not find him competent to proceed at this time.
All right, that, based upon that, we would need to institute a new inquiry, right?
Yes, sir.
Okay, and you're prepared to do so? Submit appropriate order?
Yes, sir.
Okay.
As Mr. Rubens is without funds, can he have a state-funded evaluator?
You'd need to file an appropriate motion to accompany that, and assuming the assertions are correct based upon what you've told me about him being at the hospital and just returning, then the court would assume that he would qualify, would file the appropriate motion.
Yes, sir. Will do.
Let's put a control date on this. Let's don't wait too long. How about the second date in June? You think we realistically, I don't want to wait too long. If you can get your orders in quickly, I think we could get the evaluation done by then. Mr. Switek, I just don't want him to sit for too long, right?
Right. What is that second date? Let me double check. I know I'm going out of town, but it's not till 22nd.
And of course, if the report comes in before that, we should be able to advance it, right?
Yes, sir. Yeah, I can do that. I'm here anyway for 3850, Mr. Stoffel at 2:30. Can we do it at that time?
Yes, sir, we'll set it then. And once again, if the report comes in before then, please advance it, so we don't want that defendant to sit longer than need to be,
Yes, sir.
okay?
And then I've got Mr. Cohen who's on Zoom.
Say again?
Mr. Cohen, Adlai Cohen, and 21 CF 1584. I have some documents which, if I can approach.
Yes, sir. State have the benefit of those?
Yes, Judge.
And your client's name again is?
Adlai Cohen.
I don't see him in the waiting room. I've got Mr. Murphy, Mr. Griffith, and Raquel.
Raquel may be the correct one. That's his mother. Because he doesn't have internet access. He's probably using his mom's phone.
Is that him?
Yes.
Go ahead.
Your Honor, I think we may have reached an agreement with the state on the issue of the curfew on holidays. And your proposal is?
That's correct. We would have no objection to probation having the ability to modify his curfew to attend religious events at their discretion. The Jewish holidays are rotating, so instead of putting specific dates in there, I just ask that he get with probation in order to have his curfew modified to attend specific religious events that would be out, that he would be out until 11 p.m. some evenings for.
And the necessity for that is reflected on this document that says major holidays, major Jewish holidays, in the packet that I gave you, Judge.
Right, because the motion requests additional modifications, right?
Yes.
And the state is agreeing only to the religious holidays modification.
That's correct.
And instead of, restate to be sure I'm clear, instead of adopting the schedule, you're simply saying that you want the court to give probation the authority to modify the schedule based upon his request concurrent with the holiday schedule.
Yes, Judge.
Okay.
Similar to the discretion we give probation for work or school.
Okay. And these documents, are you asking them to be placed in the record, or are they for?
Yes, sir.
All right. Now, some of this has non-public information, right, Mr. Switek?
Yes, sir.
The assessments and reports. So these two would be non-public, Madam Clerk. Marked as exhibits as to the motion today. But just those two reports, right, Mr. Switek? The rest of them are just public exhibits, correct?
Yes, sir.
Okay. And that will be the next composite exhibit. All right, and do you have a proposed order on that, Mr. Switek, or you want to run it by the state?
No, I'm going to have to draft one.
Okay. All right.
We just came to agreement this morning.
All right, so I'll grant the motion based upon the state's agreement, and you'll prepare an appropriate order.
Okay. We're also here.
Thank you very much. Good day.
Your Honor, we've got other,
Well, I was talking to your client.
well, I need him to testify. There's other things.
Oh, I'm sorry, I thought that concluded that.
No, there's other things to be addressed.
Okay, all right, go ahead then. Apologize.
Mr. Cohen, can you hear me?
Yes, sir, I can hear you.
All right. And could you identify yourself for the record?
My name is Adlai Cohen.
Okay. And you're the same Mr. Cohen that's being supervised under case number 21 CF 1584 here in Okaloosa County?
That is correct, sir.
And where do you reside now?
I reside in Maryland. Do you need the full address, sir?
No, I don't need it. Who's supervising your probation?
The name of the probation officer is Agent Hernandez.
And that's with the state of Maryland probation?
That is correct, sir.
Who is Dr. Gamble's?
Dr. Gambles is the state offered psychologist. She's the one that I completed the program with, and I'm also doing private sessions with her after completing of the program.
Okay. And how long did the program last?
52 weeks.
And you also received counseling with Lois Velardes?
That is correct. I've been going privately through Luis Velardes, even prior to the programming starts and after as well.
Okay. And so how long altogether?
And really since I came to Maryland, so we're looking since July of 2022 until to this day, and we'll continue to go.
And how long have you been on probation?
I've been on probation since May of 2022.
How are you doing on your costs and fees and all that?
I'm keeping up. I'm actually, each month I'm paying double than what I should pay.
Okay. And I've given the judge a receipt that you provided to me, and what is that a receipt for?
And so it was about maybe close to a year ago, I made a phone call to Officer Shelton, and where we talked about various things, and in that conversation, she reminded me that I still have a balance due, I guess, with the probation in Florida. So this is what I paid.
Okay. And that's cleared now?
I believe so. I mean, I'm not getting and approved that this debt has been cleared, if you will.
All right.
But I paid what I was owed, which I believe was $303.68.
All right, now back to Dr. Gamble's. She authored a safety plan. Are you familiar with it?
Yes, sir.
And what do you understand the safety plan is?
From the safety plan, it's basically a guide of to help me to stay on the right tracks, stuff that basically give me little guidance on how to help myself in the future, near and far.
Okay. And her recommendation is that you no longer be required to wear the GPS monitor. Is that your understanding?
Yes, sir, I saw that.
And of course, her conclusion was at the last page of that report, Judge. All right, you also been seen by Ms. Velardes, and
That's
she authored a report as well for the court. What's your understanding of her recommendations?
From what I understand from her, she talked about it, if I remember correctly, about what we have worked in our sessions, and then, if I remember correctly, basically saying that once again, stuff that I can do to help myself, and if I remember correctly, basically stating of a low-level risk that I am, that she at least see me as.
You're asking the court to waive the GPS monitor?
That is correct, sir.
And why do you want that waived?
There are many reasons. I guess to start off with is at my line of work, working in a carpentry shop and going through like construction zones and stuff like this, it really does hinder me in ways, going up ladders, going in tight spaces. I'll be honest, this GPS is very, very bulky. It's very big. On a different, on another reason, for whatever it's worth, I truly believe that I am no big threat and danger to society, and so I don't see how this is really helping. And also, if I may add, also to the benefit of my personal well-being, of self-insurance, security, esteem.
All right, and that's keeping with Dr. Gamble's report with her recommendation of no GPS and minimal supervision, correct?
Yes, sir.
All right. You're also asking that you be allowed internet access. Why do you need access to the internet?
And, really the first reason that I'm really thinking about, first from, the world that we're living in, it is every day gearing towards more and more technological. And I'm saying the biggest thing that really kind of hinders me, if you will, my sister, she lives in Israel, and we're very close. We became really close as we get older, and to have the ability such as WhatsApp, to just be able to talk, whether it is, just quick sentences, whether it is to share, songs that we heard and we thought of each other, and to stay in contact, really, that's what I would say. Another reason, also for work. I know my boss, like I said, he's a carpenter, and he's an old carpenter. He's doing everything sketches by hand. And he came up to me months and months ago, and he asked me if I would be interested in learning a program about how to do 3D sketching, because it's something that a lot of my clients are asking for, apparently. And obviously my boss knows that I'm not allowed to have technology and stuff like this. So I told them, you know, we just have to wait and see how my time goes. And you know, if really, these days going to a restaurant, you have a QR code for the menu. You know, just something that is, in some aspect it's sad to say, but we're just so dependent on it.
All right. We put in the motion, and I ask you today, you'd be willing to have some monitoring program installed, such as net nanny, to ensure that you don't go to
Absolutely,
websites that you shouldn't?
absolutely, yes, sir.
Those are my questions for Mr. Cohen, Judge.
State, have any questions?
No, Your Honor.
Okay. Anything else?
No, Your Honor.
Just arguments?
I just rest on the motion, Judge.
All right, state.
Judge, we would object to internet access and GPS removal in this case. This defendant pled to possession and transmission of child pornography. That was as part of a written plea agreement that was with the state. We put these safeguards in place within that agreement. As for the GPS, the defendant is eligible under JLA. He pled to 8270715. If you'll refer to the information, there are victims as young as 8 to 10 within that. In addition, GPS is when deemed necessary by probation under 94830. It can also be required. And given that and the safety concerns, we would ask that the GPS remain in place. As for the internet access, 94830 subsection H actually goes over certain conditions of sex offender probation. And that does go through the qualified practitioner making a risk assessment that approves and implements a safety plan. But that safety plan has to include accessing or using the internet or computer services. There is no mention within the documents provided by Mr. Switek regarding the internet. So we would object to internet usage at this time based on the documents that have been provided.
Mr. Switek.
I would point out that Dr. Gamble's report does say minimal supervision and no GPS. And the need in today's society for internet access is, there's no way for anybody to get ahead without it.
The one part of the proffered testimony that the court takes consideration of is the issue regarding his work. And so the court will modify the terms of access to allow him to have access to the internet under the for his work and under supervision at work. I think he indicated that his supervisor was interested in having him learn to draft electronically and those sorts of things. So he'll be permitted to do that under supervision of his employer. That would be an exception. The balance of it, based upon the terms and conditions of the plea agreement and the supervision, would remain outstanding.
All right, thank you, Your Honor.
All right.
I'll get an order to you. Well, to Ms. Berrickman today.
All right, thank you very much.
All right, thank you. Thank you, Mr. Collins.
Anything else for you today, Mr. Switek?
No, Your Honor.
Okay, thank you. Ms. Merrifield.
Good morning, Your Honor.
Good morning, Ms. Merrifield.
Brittany Merrifield on behalf of Mildred Martinez and 24 CF 984. Ms. Martinez is present. We're here today on her petition for expungement based on the certificate of eligibility that was received by the Florida Department of Law Enforcement in February of 25.
All right. Does the state intend to reverse or demur the petition?
No, Your Honor. We reached out to the victim in this case. They confirmed that they are amenable to the record being expunged or this charge being expunged, and the state is not going to file a traverse demurrer.
Petition's granted. Do you have an order?
Yes, Judge, I have an e-file, but I also have a paper copy.
Please bring it forward. Let's take care of it now.
Thank you.
Anything else for you today, Ms. Merrifield?
Yes.
All right, thank you now. Good day.
Thank you.
Mr. Patel.
Good morning, Judge.
Good morning, Mr. Patel.
Jay Patel on behalf of Haley Diane Hare, 21 CF 1591. We're before the court on a petition to expunge pursuant to a stand your ground dismissal.
All right, and say again your client's name?
Haley Diane Hare.
Okay. State, well, I think the state still has to say whether they intend to traverse a demurrer, although that it's with a dismissal on the stand your ground.
That's correct, Your Honor. The state does not intend to file a demurrer order first. The state did reach out to the victim's father last week, notified him of the hearing. And so was the victim's mother with a letter. The father indicated he did not wish to be present or make a statement. So at this time, the state would concede that the defendant is eligible for the expungement.
All right, do you have an order?
Judge, I've sent it to Ms. Natali.
All right, all right, granted.
Thank you, Judge. May I be
All right.
excused?
Yes, sir, good day. Yes. Are you also here on Mr. Shaw's other cases?
Mr. Shaw's here for a second.
Oh, okay, all right, very good. All right, Mr. Shaw. Good morning, Mr. Shaw. Good to see you back in my courtroom.
Thank you, Judge. Good to be back.
Judge, good morning, sir.
Good morning, Mr. Flowers. Susan Cole first.
Yes, Your Honor.
All right.
Good morning, Judge. Tim Shaw and Mike Flowers for Susan Cole. This is 22 CF 2824. Judge, just motion to readdress the bond issue. There was a pretrial detention, and it might be easier if I just go quickly through a little timeline because cases getting kind of old. November 5th of 22 was the date of the event in this matter. November 7th, there was a first appearance where Ms. Cole was released on bond and pretrial services supervision. No contact with the family was later added a couple days later. November 29th, November 29th of 22, information was filed on second-degree murder. June 23rd of 2023, the state secured an indictment for first-degree murder. Ms. Cole was rearrested on June 23rd of 2023. State filed a motion for pretrial detention on June 26th of 23, despite Ms. Cole having been out, obviously on bond since the November 7th date and having not violated any conditions of the bond. June 29th, bond was denied, and Judge Ketchell's order indicated that pretrial detention was appropriate in this matter. Obviously, discovery's been had. It's a, obviously very, very big case. We filed a motion to set bond on February 12th of 25, so we're here today. There is a stand your ground motion to dismiss hearing set on May 16th of 25. Ms. Sandler and I have obviously discussed the issues before the court today. Obviously, we need to show the court that since the entry of that pretrial detention, there's been a change of circumstances. And as such, Judge, when Judge Ketchel, the court may have had benefit of the audio recording from that ruling. The actual written order is very short, but the Judge Ketchel's decision was primarily based on the belief that Ms. Cole could be a flight risk because she had a CD at the time. She had sold a home and had about $125,000, I believe it was at the time, that was potentially available for access. The circumstances have changed. At this point, Ms. Cole, the CD has been renewed for 2 years. It's at the bank. We are certainly agreeable to the court putting any kind of restriction on that money being subject to a court order prior to any disposition of those funds. The other issues, Judge, are that Ms. Cole had about 8 years ago bilateral mastectomy. Since she was rearrested in June of 23, she's been unable to go to her MRIs that she's supposed to get annually for her cancer care to make sure, you know, that she's still cancer-free. She has indicated that she is treated for, or needs treatment for lupus, being not provided at the jail. She was diagnosed, according to what she told me, by Dr. Cooper in 2023. She has issues with sleep apnea, and of course, she can't have her CPAP machine there at the jail. But she's been a model prisoner at Okaloosa County Jail since June of 23, and she's gone from maximum usually to general population. There's been no disciplinary reports. Her current husband, who's present here in court today, is 72 years of age, 100% disabled Army veteran, and needs assistance. And then, of course, the court's aware of my difficulty getting to the jail to actually assist Ms. Cole. And so, based on those changes in the proffer, Ms. Sandler and I discussed just proffering this information to the court. But those are the basis for the motion today, Judge.
Any other information on the 903046 factors that the court should be aware of in making this decision as far as the proffer?
No, Your Honor.
Okay. Ms. Sandler.
Your Honor, the state does not believe that there have been an example of any material change in circumstances. Ms. Cole would still have access to her money through a CD. I think it's common knowledge that a CD does not make someone less liquid in assets. They just take a penalty and withdraw. It is not the unfettered access to funds that is concerned. It's the access to funds that present a flight risk when someone is facing a mandatory life sentence. And if Ms. Cole is married, which the state just got proof of at 9/22 this morning, her spouse would also have access to her funds, and that makes her even more likely to flee. Just for the court's information, the state did proceed on Arthur at the hearing and not on the statute. And the court did find that the state met its burden under Arthur, which is a higher burden than beyond a reasonable doubt. It is honestly the highest legal burden there is. So when people say beyond a reasonable doubt is the highest legal burden, that's actually not true. In the state of Florida, it's the burden in an Arthur hearing. And that makes her constitutionally ineligible for bond under Section 114 of the Florida Constitution. So she's technically not even really eligible for bond. But be that as it may, the state has really grave concerns about Ms. Cole, and that is because when she was given her notice of pretrial supervision, it very clearly says at the bottom, cannot leave the state of Florida without court's permission, and she signed it on 11/07/22. The state did reach out because Ms. Cole did make a representation that she was married, which was not a representation made at the Arthur hearing. And with pretrial services, and Ms. LaCroix with pretrial services stated that the only note she had in her system was that Ms. Cole reached out on 5/5/23 to get permission on 5/4. She called on, sorry, the notice dated 5/5/23. Defendant called to get permission on 5/4/23 to go to Andalusia for a few hours to help set up her ministry function. Defendant was given permission and traveled there and back yesterday. However, after the fact, I saw she must get the court's permission prior to leaving the state. I spoke with the defendant again today, advising her I gave her inaccurate information. She cannot travel out of the state even for a few hours without the court's permission. But she is covered for yesterday since I had previously approved it. However, in the future, she must get the court's permission and speak with Officer Robbins for further clarification next week. The marriage certificate the state was just supplied with this morning at 9:22 a.m. is dated on 2/22/23, which precedes the Arthur hearing and is not noted in pretrial services communications at all from when the state reached out to pretrial services. Now, Ms. Cole knew that she was supposed to get the court's permission to go out of the state and not just pretrial services permission to go out of the state. So the state had very grave concerns that Ms. Cole not only once, but twice, had never let anyone know the first time when she left to go get married, which it would not be a material change in circumstance because she got married before the Arthur hearing. But she left the state without the court's permission, knowing full well she needed the court's permission. And the state anticipates she will plead, well, I called pretrial services. But the whole point is that the state believes that that would make her, that would show the court that she would not follow any conditions of release that the court would put on her, that she would potentially leave the state and then try to plead ignorant. Furthermore, the state believes that this bond hearing is premature since the pretrial immunity hearing is scheduled for May 16th, and that hearing would be dispositive. The state believes there's been no material change in circumstances, and she still presents the same flight risk that she presented back when there was the Arthur hearing.
Mr. Shaw.
The May 16th hearing will be dispositive as to that particular issue, Judge. It won't be dispositive as to what a jury might do, following that. However, my understanding from my client is that she had permission from Lorenzo Robbins prior to go to get this. Like any defendant, in my experience of doing these things, they get permission from pretrial services. They believe that's from the court, and they're allowed to go to do what pretrial services allow them to do. So I don't believe she violated any conditions of pretrial release. The fact that she's come back, even if you believe what the state says, indicates that she has no flight risk at all. So.
I've listened to the prior proceeding, and I've listened to the proffers here today, and the state's not objected to those as proffers, right? So the court will accept that as testimony. I don't see that there's been a substantial material change in the circumstances. The court's position on that might change after our hearing on the 16th, because that could alter significantly the court's view of the facts presented in this case and the circumstances. And those facts and circumstances were deeply underlying the predecessor judge's determination of the pretrial detention. So if you wish to withdraw your motion at this time, versus the court simply denying it, the court would understand that position.
We'd be happy to do that, Judge.
All right, so we'll withdraw it at this time, and we'll have the stand your ground hearing on the 16th, and then if the defense wishes to readdress the motion for modification at that time after that hearing, then we'll do so.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Judge, I think I have another one on the docket. It's,
yes, Sean Robertson?
Yes, Judge. My understanding, Mr. Robertson had filed a motion to modify the terms of his probation. I think an order was already entered allowing that, and then a subsequent order setting this hearing came up. I think the issue's been addressed. I've spoken with Mr. Robertson about it. I think it's been addressed with his probation officer, and it's already been handled.
All right.
Correct?
Yes, sir.
Do you believe that's correct?
Yes, sir.
All right. Okay, all right, so that's simply removed from the docket.
Thank you, Judge.
Thank you, Ms. Shaw. Good day.
Good day.
Mr. Hardy. Good morning, Mr. Hardy. Good morning, Madam Interpreter. If you'd raise your right hand, please. Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing?
Your Honor, at this time, Mr. Romero is going to withdraw his previously entered plea of not guilty and enter a plea of no contest as charged. Our agreement with the state is 24 months probation, $515 fines and court costs. There's a 3-year driver's license suspension, 1 session of the victim impact panel. There is restitution we've agreed to reserve on because Mr. Snell did not have a number yet. And probation will terminate upon completion of the payment of that restitution and the victim impact panel. Your Honor, if I can approach.
Granted.
And for the record, Your Honor, this is not a downward departure.
Count 2 is a misdemeanor.
Yes, Your Honor.
So that is, what's the disposition on the misdemeanor?
Time served.
Time served, okay. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
You may put your hand down. With the help of the interpreter, were you able to understand what Mr. Hardy just announced to the court?
Yes.
With the help of the interpreter, were you able to read and understand the plea form?
Yes.
And is what you heard Mr. Hardy just announce what you read in the plea form?
Yes.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes.
And that says to me, you believe the state has the evidence to prove your guilt and you're not going to contest that.
Yes.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Okay, yes.
In this case, adjudication will be withheld. You'll be placed on 24 months of probation with the standard conditions, the fees and costs that were announced, driver's license suspension. Has Mr. Hardy answered all your questions about this plea form and how it affects you?
Yes.
And are you satisfied with how he's represented you?
Yes.
Are you a U.S. citizen?
No.
Do you understand that this plea may have some effect on your ability to remain in the country?
Yes.
Does that change your willingness to enter into this plea?
No.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. You'll have to report to probation and they'll give you some instructions on how to do that.
Thank you, Your Honor.
It's a withhold.
Thank you, Your Honor. That's all I have.
Thank you. Yes, Mr. Hardy, good day. Ms. Dudley. Good morning, Ms. Dudley. It's good to see you again.
Good to you, Honor. I have Dante Sheffield in 23 CF 1776. We have submitted a petition to expunge his record, and we also submitted a certificate of eligibility from the Florida Department of Law Enforcement.
All right. State intended to reverse or demur the petition.
No, we don't, Your Honor. We did reach out to the victim, notified him that he would be receiving a subpoena for this. Checking the courtroom, he is not here. He also indicated that he was fine with the expungement and that he thanked us for the information. So at this time, Your Honor, we would have no objection and we do not intend to traverse or demur.
The petition is granted. Did you provide an order?
I did, but I have a hard copy as well, Your Honor.
Perfect. Let's take care of it right now. Thank you, Ms. Dudley. Thank you, sir.
That's all I have, Your Honor.
Thank you, Ms. Dudley. Good day.
Yes, sir.
Ms. Jaquith.
Your Honor, I signed up before several other attorneys have gotten here. If you'd like to take the private attorneys first, I do have several, please, so.
Okay. Mr. Browning. And then that's the last I have on the list, so the rest of y'all can do scissors, rock, paper. Who's next, okay?
Trial by combat?
Yeah. Mr.
Judge,
Browning.
yes, Judge, Corey Browning here on Angela Lawrence, Judge, it's 18 CF 1764. We're here on a petition to expunge.
All right. State intent to reverse or demur the petition.
Angela Lawrence.
Yes, Angela Lawrence.
There is no objection, Your Honor. We have reached out to the victim. There was no, we notified them to be here. There was no objection to the petition to expunge. The state does not intend to traverse or demur.
Petition's granted. Granted. Thank you, Mr. Brown. Anything else for you today?
No, sir.
Thank you. Good day.
You too.
Good morning, Mr. Powell.
Judge, I have Tommy Lovett on the docket. He's present approaching. We're before the court on a violation of probation.
All right.
Judge, I've been talking with the state. They're going to dismiss the VOP. This was based on a new law violation in Santa Rosa County that was promptly dismissed. The court previously agreed to set a bond for Mr. Lovett based on the facts of that new law arrest. And so the state's not going forward on the VOP. We would just ask, he does have some outstanding conditions. He hasn't been on probation very long, but he did lose his job as part of the arrest. So he needs a little bit of time to do some of the DUI conditions, but the state's not going forward on the VOP.
Okay.
That's correct, Your Honor.
State's dismissing the VOP.
That's correct.
All right, VOP is dismissed. When does he turn, I guess I'm confused about what your request is there, Mr. Powell. Is he just asking for a little leniency on the time?
No, Judge, I just wanted the state and the court to be aware that he does have to do like the DUI school and some classes, but because he did lose his job, he's a little behind financially.
Gotcha.
And so there are those outstanding conditions, and he's working on them.
Okay, so, all right, I understand. So you're simply asking for the probation to be considerate of the circumstances based upon the dismissal of the VOP and his financial situation?
Yes.
Okay, and so, understood. And the court will take that into consideration.
He's scheduled to check in the beginning of, when was it supposed to, May 5th?
May 5th.
Would he need to go today to check into probation, or just check in?
Since the dismissal, will he need to report today, probation?
Trying to is he on felony?
He pled the misdemeanors, and so.
JCS thing.
Is he on JCS probation?
Yes, sir, I was,
Yes.
I did online calling.
Yeah, he's on JCS probation.
Okay.
So I would simply check in with them to be sure that understand that the VOP's been dismissed and that everything's okay.
Very good.
And then just follow their directions.
Thank you, Judge.
Okay.
That's all I have.
Thank you, Mr. Powell. Good day.
Good day. Good to see you.
Thank you, sir. Good day. Mr. Catalani? And I show you one client with 3 cases, is that right?
That is correct, Judge, but I think we're here set for 2 cases. How are you, sir?
I show the 3, though. I've got 2700, 2020, 2685, and 202204 is what I show on the docket.
Your Honor, is there a 2025 today?
I don't see the 25 case.
Your
Madam
Honor.
Clerk, hold on just a second.
Yes,
Do
sir.
we need to pull that up today?
No, Your Honor, that's a new charge, and we were asking that these cases, I made a mistake, I thought there were two VOPs, there's actually 3. We're asking that these be moved with the 2025 case, and the pretrial on those is going to be on May 12th.
Do you see that, Madam Clerk? 477. Okay. So, yes, I show the 25-477 to 705-12. He made a not guilty plea on 417 on that case. Stating the objection to moving the 3 VOPs to run with the new charge.
No objection, Your Honor.
All right. All right, so you entering a denial and on those 3 and asking that they run concurrent with the new charge.
Correct.
Okay.
Yes, sir.
So ordered.
And we also have a motion to set bond on the 3 VOPs, Your Honor, but they were coming in after the pretrial. Do you think we can address them on May 12th, or we still have to do them on May 29th? I filed it already.
We can, the state prepared to address them today, or do you need to 5/12?
I think we're going to need till 5/12. ASA Snell is
Very well.
the ASA who would be
All
able
right,
to handle
we'll address them on 5/12, assuming that, because it's a big docket, we'll try to get to them. If we don't have time, then we'll move them on to the next date. Okay?
Yes, sir, thank you.
All right, thank you very much, Ms. Cadillac. Anything
also-
else for you today?
Yeah, thank you, Your Honor. I'm also filling in
So,
for...
hold on.
I show that the bond hearings are set in first in front of Judge Okaloosa, and I'm in the hearing to figure out why. So that the 529 days would not be the correct date. If it is the notice of hearing says May 29th in front of Judge Okaloosa, so it's set in front of a different judge for the bond hearings.
So that's an error.
Yes, Judge.
All right, so the bond hearings are actually not set. So we'll try to hear them on the 12th, and if we don't get to them, you'll need to set them on one of the miscellaneous dates.
Yes, sir.
But investigate how that happened,
I will
okay?
take care of it today.
Okay?
Thank you, I'll see you later. Your Honor, I'm also filling in for Mr. Jason Cobb, if I may announce his case.
Yes, sir, go ahead.
It is Darby with a D, D-A-R-B-Y. I think it's Bordeaux, Boudoir, B-O-U-D-R-E-A-U-X.
Boudreaux,
Yes, sir.
is that right? Boudreaux?
Is
Okay.
that correct? I'm sorry about that. And Your Honor, what we would like to do on that case, and Mr. Cobb is asking if we could please set it for May 12th docket for entry of a PTI plea agreement.
State?
Yes, Your Honor, we spoke. We feel like the best situation right now, this was a situation where we're waiting on some payments, but we want to go ahead and move this, and so we're going to do a PTI with a plea on that date with the understanding that the defendant is going to explicitly agree that if she does not pay, she will go straight to sentencing based on the PTI. And so we're going to want to enter a PTI with a plea at that time, Your Honor.
All right. We'll see you on the 12th. Stay in touch with Mr. Cobb, okay? Thank you.
Your Honor, that's all I have.
All right, thank you. Good day.
Thank you, sir. You too.
Your Honor, I do have one client appearing via Zoom, court authorized,
And who is that?
Michael Murphy.
Yes, ma'am.
He did email me and let me know he was on the Zoom, but I can wait on him, or we can do him first.
He's joining now.
Perfect. Your Honor, that is Michael Murphy. He is before the court in 24 CF 1593. We've reached an agreement with the state, and I believe the state still needs to file an amended information, but essentially we're adding a second count so he can plead to a failure to redeliver. So count 1 would be the grand theft auto, that would be null prost. Count 2 will be a failure to redeliver leased property, 812.155 sub 3. So count 1 will be null pros, count 2 he'll be pleading no contest. The agreement with the state is to withhold adjudication, assess $515 in court costs, and a $150 cost of defense, with those financial obligations being due within 180 days. And there is no objection to the score sheet in this matter. May I approach?
And just for the court's awareness, I did file that amended information, should have just been filed this morning, so I know it'll take some time, but we did file it as count 1. The grand theft auto, count 2 is the failure to redeliver leased property.
Madam Clerk.
It hasn't been processed yet, but it's in the queue.
All right.
Sorry about that
All
late
right.
filing, Judge.
Mr. Murphy, can you unmute yourself, please? Mr. Murphy, were you able to hear what Ms. Jaquith said?
He looks like he might be frozen, Judge. I know he was having some issues with the Zoom. Getting on.
I got him.
There we go. There he is. Okay.
Were you able to hear Ms. Jaquith, Mr. Murphy?
No, I wasn't.
Mr. Murphy, what I announced was that you would be pleading no contest to the failure to redeliver leased property, with the agreement being a withhold of adjudication, $515 in court costs, and a $150 cost of defense, and that you'd have 180 days to remit those payments.
Okay.
Is that what you've agreed to do?
Yes, Your Honor.
All right. Are you located in the state of Florida?
No, sir, he is in
No, I'm
Missouri.
actually in Missouri.
All right. You're about to receive an oath to testify truthfully in the state of Florida. Do you agree to accept that oath in the state of Florida and be responsible for a violation of that oath in the state of Florida, which can include criminal sanctions such as perjury or civil sanctions such as contempt?
Yes, Your Honor.
Raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
All right, you can put your hand down. Now that you were able to hear Ms. Jaquith, did you sign the written plea form?
Yes, Your Honor.
How old are you?
34.
How much school do you have?
Mr. Murphy, if you can hear us, you're frozen again. If you could shift a little bit.
Yeah, it's breaking up.
The judge asked how much school you've had.
Not a whole lot.
Did you graduate from high school?
No, I didn't.
How far did you go in high school?
Probably got to about 10th grade.
All right. You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes, Your Honor.
And is what you read what Ms. Jaquith told me?
Yes.
All right. You understand you're pleading no contest to the announced charges and waiving your right to a trial by jury?
Mr. Murphy, were you able to hear what the judge asked?
I didn't hear the last part.
Do you understand you're pleading no contest and waiving your right to a trial by jury?
Yes, Your Honor.
All right. And your adjudication will be withheld, and you've got the fees and costs that you're going to have to pay within 180 days.
Okay.
All right. Ms. Jaquith answered all your questions. Are you satisfied with what she's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into. Thank you very much.
Thank you, Your Honor. All right, Mr. Murphy, you can go ahead and sign off. If you have any questions, shoot me an email, okay?
All right, thank you.
Your Honor, the next I have is Sal Malaby. Female first? Okay, Sexton. Okay, Judge, they're asking me to do the females first, so if I could start with Ms. McSweeney.
All right.
Your Honor, this is Caitlin McSweeney before the court. She is before the court in a felony violation in 24 CF 2102, as well as a misdemeanor new law 25 MM 1157. We've reached an agreement as to the VOP. She'll admit the VOP, be adjudicated guilty. She previously was. We're going to modify her supervision to serve the next 6 months on community control, followed by the remainder of the original term of supervision on standard probation. Reinstate all outstanding conditions. There is a $100 VOP cost of prosecution and a $150 cost of defense. Count 2 will be an adjudication and time served, as it's only a misdemeanor charge. As to the 25 MM 1157, she'll plead no contest. be adjudicated guilty, sentenced to time served, be assessed $270 in court costs, and a $50 cost of defense, with those financial obligations being due within 120 days. We have no objection to the score sheet. May I approach?
Granted. Yeah. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. And we're taking care of two things today, your VOP and your new charge. They're different, but we're taking care of them together. Do you understand that?
Yes.
Okay. And you heard what Ms. Jaquith said, and you signed the written plea form?
Yes, sir.
And as to the VOP, you understand you're admitting the VOP?
Yes, sir.
And that says to me, Judge, I violated just the way the affidavit report says I did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes.
As to your new charge, do you understand that you're pleading no contest in the new charge?
Yes.
And waiving your right to a trial by jury?
Yes.
And in that case, you're going to be adjudicated guilty and be sentenced to time served with the fees and costs that have to be paid within 120 days.
Yes, sir.
You satisfied with how Ms. Jaquette's represented you?
Yes.
And has she answered all your questions?
Yes.
Court finds the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Your Honor, next is Cleophas Mendoza. Your Honor, Ms. Mendoza is before the court in one felony case and 3 misdemeanor VOPs. We're resolving all of them today. As to the felony case, that's 24 CF 2469, should be pleading no contest to count 1. Count 2 will be dismissed by the state. She will have a withhold of adjudication, be placed on 2 years of probation. There's a $40 per month cost of supervision, $510 in court costs, $150 cost of defense. There is $230 in restitution to Pamela Otteson, Ottesen, and no contact with Pamela Otteson. $99.32 cost of investigation to the Niceville Police Department. 24 hours of community service work. $60 in restitution to James Mobley Maynor, Mainor. $128 restitution to Michelle Lynn Vaden, Vaden, and $330 in restitution to Sandra Sibbett Walker. As to the misdemeanor VOPs, she'll admit the VOPs, she'll be adjudicated guilty, revoke and terminate that supervision, be 60 days county jail concurrent amongst all 3 with credit for all time served. $50 VOP cost of prosecution in each case, $50 VOP fee in each case, and a $50 cost of defense in each case. May I approach?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. And you put your hand down. You heard what Ms. Jaquith said, and you signed the written plea form?
Yes, sir.
All right. And you got 2 different things going on today. You got your misdemeanors and your felonies, and we're taking care of them together. Do you
Yes, sir.
understand that?
Yes, sir. Your Honor, may I pause for just a moment?
Yes.
She wanted to ask me something. so-
Yes. And the misdemeanors are VOPs, right?
Yes, sir.
All right. And your felony charge is a new charge, right?
Yes.
Okay.
Yes, sir.
Okay. And now as to your misdemeanor VOPs, you understand that you're admitting your violations.
Yes, sir.
And that tells me that you violated just the way the report says that you violated.
Yes, sir.
Do you understand by making this admission, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
As to your new charge, do you understand you're pleading no contest to those charges?
Yes, sir.
And by pleading no contest, I understand you to say that you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, sir.
And do you understand by making this plea, you're waiving your right to a trial where the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
And in this case, you'll be adjudication will be withheld on the felonies. You'll be adjudicated guilty on the misdemeanors. The misdemeanors will be 60 days county jail credit for all time served. Your fines, fees, and costs, plus the cost of defense. And how much time will she need to get those paid?
I would ask the court to give her 180 days just so that she can get on a payment plan when she gets out.
And then on your felony, you're going to be on 2 years of probation with the fees and costs that were announced, plus community service hours, restitution that was announced as well. Is that what you understood?
Yes, sir.
Ms. Duquette answered all your questions about the plea and how it affects you,
Yes.
and you satisfied with how you've been represented?
Yes, sir.
Court will find the pleas to be freely and voluntarily entered into and will accept the pleas. Thank you.
And, Your Honor, I did want to make sure we addressed for the jail's purposes that the state's taking no action on any FTAs in exchange for this plea, and make sure, or ask that Madam Clerk include that on the minute sheet so the jail doesn't email me about it later. Thank you. Also, Your Honor, Ms. Mendoza had some concerns. She is going to essentially be supervised in Crestview, but she understands she has to check in Fort Walton. She does rely on the bus to take her down there, so I have instructed her that if she doesn't get out in time to get the bus to get down there at 5 p.m., before 5 p.m. today, that she needs to be there at 8 a.m. tomorrow morning. But I just wanted to make a record of the fact that she did have some concerns about the bus and being able to get to probation this afternoon.
Understood.
And Your Honor, the next I have is Juliet Sexton. I know that was a late add-on. I appreciate the court allowing me to add her. Your Honor, Ms. Sexton is present in 24 CF 2129 and 25 CF 429. Your Honor, I have reviewed this and given her a copy, but I do need to pause for a moment to allow her to sign it. In case number 24 CF 2129, as to count 1, Ms. Sexton will be pleading to a lesser included possession of drug paraphernalia, first degree misdemeanor, 893.147 sub 1. Counts 2 and 3 will be as charged, and in 25 CF 429, she'll be pleading as charged. The agreement is for her to have a withhold adjudication on all counts. All of the misdemeanor counts will be a year of probation running concurrently to the rest. In count 2, in the 2129 case, she'll have a withhold of adjudication, 3 years of probation concurrent to all other counts and cases, $40 per month cost of supervision, $615 in court costs, $150 cost of defense, substance abuse evaluation within 30 days, and begin recommended treatment, if any, within 60 days, no controlled substances without a prescription, random urinalysis, 50 hours of community service work. She needs to maintain gainful employment or show proof of 3 job applications per week. She'll have automatic early termination at 24 months if all conditions are complete and there's been no violations. As to the 429 case, she'll have count 1 will be a withhold of adjudication, 3 years of probation concurrent. There's the additional $615 in court costs and an additional $100 cost of defense. I'm sorry, I need to change that, Judge. $100 cost of defense. Again, the same terms and conditions as previously announced. Count 2 will be a withhold, 3 years of probation concurrent. Both of those will also have the automatic early termination provision at 24 months if she's completed everything. Your Honor, I would ask that the court waive the cost of supervision at least for the first 6 months. Ms. Sexton just turned 19, actually while she was in jail, and she does believe she'll have a job, but she'll obviously need a little bit of time to get back on her feet. I'd like her to be able to put her funds towards housing rather than towards the cost of supervision. May I approach?
Yes.
And there's no objection to the score sheet.
Raise your right hand for me, please. Do Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay. You can put your hand down. You heard what Ms. Jaquith said, and you signed the written plea form. Okay. Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes.
And by pleading no contest, what I understand you to say is you believe the state has the evidence necessary to convict you, and you're not going to contest that. You're saying yes, but your face is saying, not really sure.
Do you understand what he's saying?
So my job is to be sure that you're making a free and voluntary decision, and the only way I can be sure of that is if you know and understand what you're doing. That's the purpose of the questions, not to trick you in any way, okay? All right, so you understand, you believe that the state has the evidence to prove your guilt by pleading no contest. And do you understand by making this plea, you're waiving your right to a trial where the state would have to prove your guilt? And in this case, adjudication will be withheld, and you're going to be on 3 years of probation with fees, costs, and conditions which were announced, including those substances without a prescription, and testing to assure that that happens, and that you're to get employment or seek employment. And my position is if in lieu of employment you want to seek job training or school, then I will support you in doing that. The goal here with this is to set you up for success. And if that's what you want to do, then I will support that through probation if that's what you desire to do, okay? Ms. Jacob answered all your questions about the plea and how it affects you. And are you satisfied with how she's represented you? The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you, Your Honor. Make sure you check in something. Unless for whatever reason, 4 or 5. Can't get there, you gotta get there. He's gonna give you all the information right there, phone number and stuff. And I believe next will be Mr. Malaby. And Your Honor, if I may just pause for a moment.
Yeah, that's what I would do.
Given the sentence, Mr. Malaby has been a bit hesitant, understandably, given what he's going to be sentenced to. So that would be the reason for having him sign today in court. We want to make sure this is definitely what he wanted to do.
Understood.
Your Honor, he's going to be pleading no contest as charged to 6 counts. Essentially, the memorialization of the sentence is that he's going to be doing 9 years in state prison, followed by 11 years of probation. He will get credit for all time served. However, these are all third-degree felonies, so it is structured a little bit unusually. So I just wanted to make the court aware of that before I start announcing.
Just move slow so I can follow along, and so can Madam Clerk make good notes.
Yes, sir. As to count 1, he's going to be adjudicated guilty. He'll be sentenced to 5 years in the Department of Corrections with credit for all time served, beginning on the date of his arrest, which is June 8th, 2023. And we included that information, Judge, because there was an amended information filed, and I wanted to make sure that nothing got wonky because of the way we structured the sentence. We want to make sure he is getting all the credit that he served. So hence why I outlined it that way. Count 2 will be an adjudication of guilt. 4 years, Department of Corrections. That will be consecutive to count 1. Count 3 is an adjudication of guilt. It'll be 4 years in the Department of Corrections, credit for all time served, concurrent to counts 1 and 2. Count 4 will be an adjudication of guilt, 5 years sex offender probation, consecutive to counts 1 through 3. So essentially to start once he's released. $40 per month cost of supervision, $767 in court costs, a $150 cost of defense. You will need to be affixed with a GPS monitor, which the cost will be set at $1 per day. No contact with minors, no contact with the victim AL, He will need to complete the sex offender counseling. He's not to access any internet or any internet-capable devices or own any internet-capable devices. He will forfeit all items seized by law enforcement, have a sexual predator designation, and need to comply with all associated requirements for registering with that designation. Count 4 will be an adjudication of guilt and 5 years of probation consecutive. And then count 6 will be an adjudication of guilt and 1 year of probation consecutive. Do we have any questions about any of that?
No.
Madam Clerk, are you good? Okay.
State?
Good.
Okay.
May I approach?
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, you can put your hand down. You heard what Ms. Jaquith said, and you signed the written plea form.
Yes, Your Honor.
How old are you?
34, Your Honor.
How much schooling do you have?
I have a high school diploma, dual seal, sir.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read, what Ms. Jaquith announced to the court just now?
Yes, Your Honor.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, Your Honor.
And by pleading no contest, what I understand you to say is that you believe the state has the evidence necessary to convict you of these charges, and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to excuse me, a trial by jury where the state would have to prove your guilt to the jury beyond a reasonable doubt by that evidence?
Yes, Your Honor.
And in this case, you will be adjudicated guilty of these charges. And Ms. Jaquith has gone through the sentence carefully, step by step, but condensing that is you'll be sentenced to the Department of Corrections for 9 years, followed by 11 years of probation. Now, there's some technical things about how that sentence actually works, you know, with 5 followed by 4, and then your probation with the sentences of 5 and 5 followed by 1. But essentially, that is it. 9 years followed by 11 years of probation. Do you understand that?
Yes, Your Honor.
Okay. Given the, and Ms. Jaquith answered all your questions about this plea and how it will affect you.
Yes, Your Honor.
And are you satisfied with how Ms. Jaquith has represented you in this case?
And I'm satisfied, sir.
Okay. And has she answered all your questions? Any questions left? Because I see you're hesitating about some of the questions I'm asking. What, is that because of the sentence you're facing, or there's some things that are unanswered for you that you need answers to?
Everything is fine, sir.
Okay.
I appreciate your concern.
Okay. Because my job is to be sure you're making a free and voluntary decision. And to make a free and voluntary decision, you must be fully informed, and that's the reason I'm asking the questions, not for any tricks or traps, but to be sure you know and understand what you're doing. So if you've got questions, now's the time to be sure that they're answered before we proceed further. So if you do, feel free. It's not any problem. If you need any other questions answered, I'll be happy to let you do that.
Appreciate it.
Okay, so you're all good?
Yes, sir.
Okay, and this is the plea you wish to make to the court?
Yes, sir.
Okay. The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Since he is going to be in serving time in DOC before he's released, we would ask the court waive the cost of supervision, at least for the first 6 months.
Cost of supervision will be waived until the defendant is employed and able to support himself.
Thank you, Your Honor.
And for the record, the victim and her family are aware and in agreement with this plea in accordance with the Constitution Amendment known as Marcy's Law.
Thank you very much.
Your Honor, and the next I have is Antoine McCrae. Your Honor, Mr. McCray is present in 24 CF 1314, which is a felony violation of probation. Also on the docket is 25 MM 1009, which is a misdemeanor new law offense. We're also resolving as well today. As to count 1 in his VOP, it'll be an omission to the VOP, adjudication of guilt, which he previously was, modify his supervision to serve the next 6 months on community control, followed by the remainder of the original term of supervision with the reinstatement of all outstanding conditions, a $100 VOP cost of prosecution, and a $150 cost of defense. Count 2 is a misdemeanor, so it'd be an omission, adjudicate, revoke, and terminate time served. As to 25 MM 1009, he'll be adjudicated guilty, or enter no contest plea, be adjudicated guilty, sentenced to time served, $270 in court costs and a $50 cost of defense, and we're asking the court to give him 120 days to either pay that or get on a payment plan with the clerk's office. May I approach?
Granted.
And there's no objection to this portion.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard what Ms. Jaquith said, and you signed the written plea form.
Yes, sir.
And you've got the two different things going on today. You've got the violation, and you've got your new charge, right?
Yes, sir.
We're taking care of them together, but they're different, right?
Yes, sir.
As to your VOP, you understand you're admitting the violation.
Yes, sir.
And that says, Judge, I violated my probation just the way the affidavit report says it did.
Yes, sir.
And do you understand by doing that, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And as to your new charge, the misdemeanor, do you realize you're pleading no contest?
Yes, sir.
And that says to me, you believe that the state has the evidence necessary to prove your guilt, and you're not going to contest that.
Yes, sir.
And do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
And you'll be adjudicated guilty. On your misdemeanor, it's time served, and you've got 120 days to pay all your court costs or arrange for a payment plan. On your violation, you'll be adjudicated guilty, your supervision modified to serve the next 6 months on community control, followed by the, okay, so it's the original term, there's no extension of the term, so the original term date remains the same, a modification for the next 6 months on community control, and then his original term date remains the same, reinstate all the outstanding conditions except for this modification, plus the additional cost.
Correct, Your Honor.
Okay. Ms. Jaquette answered all your questions about this plea and how it affects you?
Yes, sir.
You satisfied with how you've been represented?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Your Honor.
Thank you.
Make sure you get you get released, you gotta be there by 5. If you get released late, you gotta be there at 8 o'clock tomorrow morning.
Yep.
Because you're on CC, right? Gotcha. Clear? Okay, good luck. Your Honor, that is all I have before the court today, if I may be excused.
Yes, ma'am. Does the PD expect to withdraw from anything today so Ms. Jaquette can meet her new clients?
Nothing from me, Your Honor.
Nothing for me, Judge.
The only one that there may potentially be a withdrawal is Angelica Walker, Judge, but Mr. McKinney and I discussed that earlier, and he needs to review to see if there is a continuing conflict.
Okay.
So he's going to address that.
Okay.
Your Honor, we do have an individual on the arraignment docket, Alyssa Malamud, who we are going to be filing a motion to withdraw, so I don't know if Regional Conflict Counsel is going to be here or not. But
I won't be here this afternoon, Judge, but I will reach out to Mr. Klein's office and get any contact information they have.
All right, very good.
Thank you.
Good morning, Mr. Griffith.
Good morning, Your Honor.
Which case were you set for today, Mr. Griffith?
Rita Richardson, Judge, it's a violation of probation for her not making her full restitution payments. I believe Ms. Richardson's in the courtroom. There she is approaching the lectern.
Okay, and I actually show her on the docket as with no attorney, and you're representing her now. I didn't see an appearance.
Yes, we filed one. I just was determined I was able to represent her yesterday. And I think we got filed early this morning.
Okay. All right. State have an offer in this case?
Just one moment, Judge. I'm looking through his notes. I think it says no attorney. Judge, do you happen to know what page of the docket she's on?
She's under no attorney at the, I don't have a paper docket, so I can't tell you.
Page 8.
Your Honor,
Yes.
my understanding is that Ms. Richardson has complied with all the terms of her probation with the exception of being unable to pay the large amount of restitution.
I do have some funds now with the help of some family, so I mean, I can make a substantial, well, I shouldn't say it's substantial, but I can make a large amount and continue to pay. Actually be able to pay more than I had been in the past because my husband is now feeling better. I couldn't work a whole lot because of his illness, and so he's now made a turn for the better, thank goodness, and I can actually work a little more than I did in the past.
All right. So, and I noticed that the costs, looks like she has 0 on the costs. Those are paid on 4/15, so.
Right, my daughter paid my court costs for me.
And it looks like they were all financial, right? It's the restitution, the court costs are paid.
Yes, sir. My understanding is it's just purely her inability to pay the large amount of restitution.
I can continue to work, as I said, and make larger payments than I did before.
All right. But what's the state's desire at this point?
The state has no objection to termination and converting to a lien. It's my understanding that she owes $120,795.
Well, the report says she owes a balance of 91.
91,000?
Mm-hmm.
That's my understanding also, Your Honor.
It's paid almost 30 over the term of probation. So if the termination happens, you'll still have a civil lien for the restitution, and you can continue to pay that. Should you pay that through the clerk if we?
Yeah.
So you have to file civil lien paperwork and then it would be approved through it.
How
So-
come? I'm sorry, what was that, Judge?
Well, I was just asking if that could be paid through the clerk, and once the state files the civil lien information, then you could just simply make the payments to the clerk. There would be a fee for each of the payments that you make, similar to the fees you have to pay now.
Oh, I see.
Is that the state's desire at this point?
I believe that would be the state's desire at this point, Your Honor. I don't think that's an amount we can just continue the case for her.
All right. All right, so when's her termination date?
I thought it was the end of this month, Your Honor.
Your Honor, it's April the 28th.
All right, so at this point then, we'll allow her to terminate. The restitution will go to a civil lien. Once they file that, then you can continue to pay the clerk to resolve that.
Okay, and that's how I can pay my amount that I have? That
Yes,
way?
ma'am. Yes,
So
ma'am.
will I do something?
Well, you can, whatever you have now, you can give to probation right now, and you'll get credit for it right now.
Oh, well, it'd have to be.
Well, you have till the 28th, right, before you terminate.
Oh, okay, I got you.
Right.
I got you.
And then you terminate on the 28th, well, not you, your probation will terminate on the 28th. And you'll have then to pay through probation. After that, the state will file the paperwork with the clerk, and then you can pay your restitution through the clerk.
Okay.
Okay? We're dismissing the VOP since it's financials only at this point, and I believe the argument is no present ability to pay.
I think that would be appropriate.
Okay, so the VOP is dismissed. Okay? Okay?
Okay, thank you.
All right, thank you.
Thank you, Judge. I appreciate your courtesy.
All right, thank you now. Good day.
May I be excused, Your Honor?
Yes, Mr. Griffith, good day.
Thank you.
All right. Now, we have some other folks here in the courtroom that don't have an attorney assigned, and everyone's entitled to have an attorney represent them. If you can't afford an attorney on your own, the federal constitution and the state constitution say that the state must appoint an attorney and pay for that attorney at the state's expense. So as I call you up one by one, we'll address that question. The state may have an offer to you to resolve your case. If you feel comfortable accepting that offer without the help of a lawyer, you're welcome to do that. To get a lawyer appointed for you, you've got to complete a form, which we have here available for you. It's a goofy government form. If I hadn't been doing this a whole long time, I would be scratching my head how to figure out how to file it. It's not as bad as your taxes, but almost. And so I like to have people file it out, fill it out here in court, turn it back in. I look over it for the areas that are commonly, mistakes are commonly made, not because of any other reason other than it's a confusing form. And if there are any mistakes at all, when it's turned in to the clerk's going to reject the form, not because she's a mean person, but because the law says if there's any mistake at all on the form, the clerk is required by law to reject it. So then you have to do it again. So I believe if we do it together here today and I review it for any of those mistakes, then we short circuit that problem and you get the form to be processed more promptly, okay? So I'll call you up one at a time. Aubrey Hawks. Good morning, you're Aubrey Hawks. Do you wish to have a lawyer help you, or you would like to hear what the state has to say first?
I would like to hear the offer first.
State? Aubrey Hawks. It's a VOP.
Hold on one moment, Your Honor, sorry. We're kind of both covering for Mr. Snell's.
Well, it's a positive UA on 225.
I think right now, Your Honor, the offer would be to convert the next 6 months to community control, followed by the remainder of time on probation.
All right. Do you understand that offer? So it would increase your level of supervision to community control for 6 months. The report says you need to focus on getting a job and completing your community service hours too, but that would be community control in the next 6 months. Do you understand what community control is?
Yes, sir. So would it be an additional 6 months to the 6 months I'm already on, or would it be 6 months
Right,
from
and
today?
an additional 6 months. So will you finish the community control you're on, and they would add 6 months to that?
Yeah, I'd like to get a public defender, if
Okay,
possible.
well, you have to fill out the form. Do you have any other cases pending other than this one?
No, sir.
Okay, fill the form out, give it back to the bailiff after you finish filling it out. Don't leave until you turn it in and get a new court date, okay?
Yes, sir, thank you.
All right, thank you. Neil Matthews.
Your Honor, if I may speak, in looking at this, this is a VOP for financials.
Right.
It's going to be under the argument that there would be an inability to pay. I think the appropriate thing to do at this time, since he's past his term date, would be to dismiss this VOP, terminate probation, and convert all outstanding costs to a civil lien. Or if he thinks he can pay it off in an X amount of time, then we could potentially give him however many months he needs to pay those off. But I think right now, since we're past the term date, I think that would be the appropriate way to handle this case, Your Honor.
All right, do you understand that?
Yes, sir.
All right.
6 months to pay it off?
180 days, you think you get it done?
Yes, sir.
Okay, so you'll dismiss the VOP, allow him to he's already terminated. Well, his case is terminated. And I'll give you then 180 days
Yes, sir.
to get the payments made. Now, if you're making payments and you run short, because I know things happen, as long as you're making payments, if you need more time, you can ask for more time. But if you're not making payments, don't bother asking for more time.
Yes,
The
sir.
goal here is to give you how much time you need to get it paid.
Yes, sir.
Okay?
Is there a total on that?
Let me pull the file. It was. Sorry, internet.
I know, I'm experiencing the same problem, so.
As of right now, it appears that there's a $50 processing fee that is outstanding, plus a 4% surcharge. There is also a $765 fee for court costs, and then a $40.07 fee or restitution payment. So I would say around, I'm not a math person, around $850, $860.
Yeah, if I could just
Is 6 months going to be enough time for you?
It should.
Okay, all right, so the VOP is dismissed, and you got 6 months to pay.
Okay.
All right?
Thank you.
Thank you very much, good day.
Your Honor, and probation is terminated, correct?
Correct.
Yes, thank you.
Probation is terminated, thank you very much. Robert Peets, oh wait, he's got counsel, doesn't he?
I don't think he was appointed yet on this particular, because he has a new law violation. I don't know if he was formally appointed in this case. That was.
But he has a new law where he's been appointed, correct?
Correct.
He's appointed in this case.
Thank you, Judge.
And he's incarcerated.
All right, let's have Mr. Peets.
Number 6, JJ. Number 6, Pete's.
And Angelica Walker's in the same boat, right?
Correct.
Thomas, do you know if the depot of the
I'll have it with Walker
victim in the new law is
All right.
set before or after Black Dog? Yeah, because we might want to do it where, yeah, this is your new law case, because we might just want to go ahead and ask the fees, but cases can continue to another day, other than 5/12, if that makes sense. I see you guys filed that. Yeah, 4/20, tomorrow, we're doing it tomorrow. Okay. I'm not going to be able to.
Do we anticipate anyone else appearing remotely? Counsels?
Not that I'm aware of, Judge.
Not until this afternoon. I know Mr. Nopes is going to appear via Zoom this afternoon.
You got it? The VOP. Okay, thanks. Thanks, AJ. Your VOP, I'm gonna get appointed to that today. Good morning, Judge.
Good morning, sir.
This is Mr. Robert Peets. Case number for that new VOP, I don't have in front of me, Judge, but I also...
It's 23 CF 2683.
Thank you, Judge. And I have him currently for the 25 CF 414, Your Honor.
Correct.
This morning, I'll be entering a denial on the VOP. If we can keep both cases set for the 512 pretrial docket, Your Honor.
So ordered.
Thank you. We'll discuss. Thank you.
Angelica Wilson.
Jason McKinney on behalf of Ms. Walker. Judge, she has two new case numbers, which is 25 CF 466, in which RCC is appointed, and 25 CF 764, in which I am appointed. She has no counsel on the violations of probation. If it's the court's intention to appoint the Office of the Public Defender.
It is.
And then we are running through our conflict analysis, and we'll go from there. As of right now, the 764 case is scheduled for pretrial conference on the 14th July. And with a plea date of the 15th of May. I think it would be prudent to track with that case, as I anticipate from speaking with Ms. Jaquette that she is going to be continuing her case to match that case to see where we're at.
Okay, so a denial on all of these and let them travel together?
Yes,
and
sir.
if there's some other disposition, you can advance them on the docket sooner?
Yes, Your Honor.
Okay, all right, very good.
Yeah, he's already had an expert appointed. Okay, so we're still waiting. This is another date. Okay, 2/13. Right, this is competency report, 3/19. Competency. Okay, so he's good to go. So he's been evaluated. Not covered.
All right, to John Tarver. All right, good morning. You're here today without a lawyer. Do you want a lawyer to help you, or would you like to hear what the state has to say first? Okay.
Your Honor, at this time, if I'm not mistaken, the basis of the violation of probation was a new law, felony WLSR in another county, is that correct? And I think based on that, we would modify probation.
It's two, it's leaving the county without permission and the new arrest.
Okay. We would modify probation to add 48 hours of community service work, Your Honor.
So are you dismissing with the
Oh,
agreement
no,
to
it would be-
modify?
I'm sorry, it would be an adjudication of guilt modified to add 48 hours of community service work, or admit the violation.
Because he's already been adjudicated guilty.
Correct, Your Honor.
All right. So there would say that you would, so the only change would be the additional 48 hours of community service?
That's correct, Your Honor.
No, that's.
Do you understand?
Yes, sir.
Are you willing to do that?
Yes, sir.
Okay, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? All right. You understand that by doing this, you're admitting the violation? And that says, Judge, I violated just the way the affidavit report says it did.
Yes, sir.
And you're waiving your right to a hearing where the state would have to prove that.
Yes.
And you've been previously adjudicated in this case, so that the adjudication remains in place. You'll be assessed $100 cost of prosecution, And you'll have the additional 24 hours community service that will be imposed. How many hours?
48, Your Honor.
48 hours, sorry. 48 hours community service to be imposed that you'll have to do. Your termination date will remain the same.
Okay.
As you do, is that your agreement?
Yes.
The court will find the plea to be freely and voluntarily entered into, will accept the plea. No prints needed, previous adjudication. Check in with probation before you leave, and they'll give you some instructions. All right?
TARVER, it's 24 CF 769.
Excuse me, Judge, do I have the opportunity to pay the 48 hours off?
Say again?
Do I have the opportunity to pay that off?
Any objection if he wishes to pay them off?
No.
Okay? He'll be permitted to if he so desires.
Yes, sir.
All right, thank you. Aubrey Hawks,
769.
all right. So Ms. Hawks, you listed your income here, a very specific amount. Is that what you receive from employment?
Yes, sir.
And you take that home every 2 weeks?
Yes, sir.
So there's some months that you get 3 paychecks?
Yes, sir.
Okay. And so you're on salary, or is that hourly, or?
It's hourly, and then I make cash tips as well, but I didn't know if there was like a place I needed to put that.
Okay. So that's a very specific amount. Is that, it doesn't ever vary?
No, sir, I work the exact same schedule every week.
Okay, okay. Okay. Okay, it appears you do qualify. I'll turn this into the clerk. The clerk will review it. If they say you don't qualify, they'll tell you why. If you think they're wrong, get everything you have that shows they're wrong, give it to your lawyer, and bring it to court with you next time, okay?
Yes, sir.
Judge, I'd like to enter a denial and ask for the second date in June.
All right. Madam Clerk?
Yes, sir. Without subpoenas.
All right. So ordered. Now get in touch with your lawyer and be back in court then, okay?
Yes, sir, thank you.
Thank you. All right. Mr. Kleins?
I'll call the people in the gallery first. I have Herman Beck. Mr. Beck is present and approaching. Your Honor, Mr. Beck is in the drug court process. I expect he'll be admitted next week.
Right.
If we could just put this on, maybe for May 15th for a control date?
Yes, Your Honor. Just to let the court be aware, he had showed up, and I think there's a little bit of a miscommunication as to what he needed to do last week. He did make himself available yesterday in drug court, spoke with Judge, and we intend on him entering the program next Wednesday.
So we'll just set it then for a control date on 5/15. And if you're admitted, your lawyer will tell you you don't need to be back because it'll just roll off of our docket, okay?
Yes, sir. Thank you.
Okay, thank you.
Next in the gallery, Your Honor, I have Brian McGriff. Mr. McGriff is present and approaching. Your Honor, I believe the state has an announcement on Mr. McGriff.
Yes, Your Honor. Mr. McGriff, the basis of the VOP was he was coming to the end, or he came to the end of term, and it was a failure to pay. We can't prove that it was willful, and so we would dismiss the VOP, Your Honor. We would terminate supervision, and we would convert all outstanding costs to collections.
Do you want to? Your Honor, Mr. McGriff would ask the court to consider giving him 9 months to try to pay this off before.
I'll give him 9 months to attempt to pay. And with that, and so is he past term?
He is, Your Honor.
Yes, Your Honor.
Okay. So you withdraw the VOP, the case is terminated, and we'll give him 9 months to pay his outstanding financials.
All right. Yes,
All right? Thank you.
All right, that's it. All right. Good luck.
Okay. So we don't mail it to him?
Well, no, I mean, you just, if you start paying court costs.
What do I start? They got an amount that I need to pay?
They'll tell you down there.
Down at the other end?
Tell them I need to see how much. Your Honor, next I have Noah Morris.
Morris?
Mr. Morris is present, Your Honor. This morning, he signed a pretrial intervention agreement. So I don't really know how probation, I didn't get a chance to ask, do you want him to take this over to probation himself directly? Okay.
And so we'll just set it for status on 5/15.
Yes, sir.
You'll carry that over to probation. If all the paperwork is filed, then you don't need to be back on 5/15, but we have to set it for status to control the paperwork, okay? All right, thank you now.
Talk to him, I'll tell you where to go. Okay. Yep. The last I have on the morning docket, Your Honor, is Candace Murphy. Miss Murphy lives near Branson, Missouri. I did receive the PTI paperwork yesterday from the state. I emailed Miss Murphy. I filed a waiver for her, so she's not here today. If we can leave Miss Murphy on the 5/12 docket, and if the court would authorize her to appear by Zoom, given the fact she lives about 15 hours away, I do expect that we will have a signed PTI agreement back from Miss Murphy at that point. I have instructed her to please review the agreement, sign it, email it back to me, or fax it to me. So we're working on getting that done. If we can just put Ms. Murphy's case on the 5/12 docket, and if the court would authorize a Zoom appearance for her.
Well, does she need to be here if we get the paperwork done?
But I'll leave it up to the court. If the court wants to leave it on for status on 5/12, that's fine with me too. And if there's an issue.
Is it with a plea or?
No, it's just a PTI. I think as long as it gets into probation, it should naturally fall.
Okay, so we'll put it on for status on 5/12.
Okay, that's fine.
With
Thank
the
you.
hopes that we'll get it squared away.
And that's all I have in the gallery. I'll turn it over to my.
Okay.
Judge, I have Gematria Hendricks.
Say again?
Gematria Hendricks.
Okay, Hendricks, please.
Mr. Hendricks is approaching in 23 CF 1260, which is a felony violation of probation.
Correct.
If Your Honor looks at the progress docket, it actually shows as closed.
Yeah, and then I also show that there's active process, and I'm not sure why that is.
We just don't have the arrest paperwork from when he was served with you anymore. I'm in contact with the warrant division.
Okay. And the reason, and so, Mr. Hendricks, don't get upset. The lawyer will tell you, whenever I see that, I don't want anybody, if there's an active process, that means there may be a warrant floating around somewhere. I'm pretty sure there's not, because you're here today, right? And so I want to be sure that's squared away, because I don't want you to be driving down the street and get stopped for a taillight out and get arrested on a warrant and sold. That's the only reason I'm raising it up.
Judge, may I approach you, Madam Clerk?
Yes.
I believe this may be the paperwork.
Okay, very good. All right, so that'll take care of it? Okay, good, excellent.
Judge, and with that issue cleared up, I'd like to call Mr. Hendricks back at the end of the docket so I can speak to the state and see if we can resolve these matters today.
Okay, no problem.
Okay. Thank you, Judge.
Gotcha.
I also have Christopher Evans Madison in the courtroom. Judge, we'd set this as a status today. This was a PTI that was returned to the docket. It was outstanding costs and 24 hours community service hours.
Correct.
We set it as a status today just to see where we're at, making some progress.
Correct.
He has not completed that yet. He has obtained employment. He's living in Florida. He's doing tree work. So his request is going to be if he can buy out the 24 hours, since he is working full-time at this point.
Objections? Buy out the community service?
No objections.
All right. How much time does your client reasonably think he needs to get his financial obligations and buying out his community service?
Judge, with his finances and employment, he's going to try to get that done by 5/12, which is our pretrial date. If we want to leave it on that date to see where we're at. Yes, sir.
5/12 is a pretty busy docket. You want to push it on over to one of the miscellaneous dockets instead?
I'm fine with that, Judge. If we want to set it on the second June date, that would be.
Well, I mean, because, just practically, that's only 3 weeks away.
Yes,
You really
sir.
think you can get it done in 3 weeks, or better to give you, instead of taking another day off of work, I'd rather give you enough time to reasonably get it done instead of making you come back in 3 weeks only to ask for more time.
I appreciate that, sir.
So,
Thank you.
June date, Madam Clerk?
I would
June-
prefer the June 19th.
June 19th?
Yes, sir.
And if you get it all squared away, tell your lawyer.
Yes,
And
sir.
if it's all paid off, you won't need to come back to court because your lawyer's simply going to announce that it's all taken care of and we're done, right?
And Madam Clerk, with the PTI return to the docket, is he paying these amounts to the clerk?
If it's restitution, there's no restitution.
There's no restitution, it's only cost of supervision, court costs, and in speaking with probation, probation usually indicates that they don't want to take payment after it's been returned to the docket.
All right, because the only thing would be the payout of the community service, right?
Correct.
So if you want to, would it be best, can you do that without an order, Madam Clerk? Okay, so I show he's got 406 plus the 259 plus now the 24 hours community
Correct.
service. All right?
Yes, sir.
Okay, so 619, and if you get it all squared away, Mr. McKinney, let Mr. McKinney know so you don't have to come back and miss another day of work, okay?
Yes, sir.
The goal here is to get it all paid.
Yes, sir.
Okay, all right, thank you now.
Judge, the remaining matters I have are incarcerated.
All right, Mr. Koch?
Judge, all my morning dockets in custody.
Okay, well, let's take 5 minutes, you get them all lined up, because I need a comfort break. And the rest of the folks in the gallery are here for folks incarcerated. Nobody else has got a case themselves in the gallery, just folks who are in jail? Okay, we'll take 5 minutes for comfort break.
All rise.
5 minutes.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. contact Dixie Dan Powell and Powell Injury Law. 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims, Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Downtown.
I'm sorry, you don't have the numbers. Bias is female and Loomis female, so I figured.
Okay, all right, very good.
Go ahead, Mr. Plum.
Yep, I'm good.
Call Michelle Bias.
Your Honor, this is Ms. Bias. She is present and approaching. 21 CF 480. We will enter a denial today. Ms. Bias has already been noticed for a bond motion on May 15th. So if we can just pass this over to the May 15th docket for that hearing.
All right. All right.
And Your Honor, just for Ms. Bias's benefit, state what is the formal offer for Ms. Bias?
The revoked term of what she scores, which I'm showing is 34.275 months.
We'll come talk to you about the score sheet. Okay. Okay?
Thank you.
All right. Yeah, you're good.
Thank you for.
Okay.
I appreciate that.
Next we have Antonio Lee.
Morning, Your Honor. We have Mr. Antonio Lee, case number 23 CF 000141. Your Honor, we would ask for this to be set for a VOP hearing.
All right, an evidentiary hearing with subpoenas?
Yes, Your Honor.
All right. When can we be ready? From the defense first, can we be ready on 5/15?
Your Honor, I'm going to be at a state at the end of, I would ask for the next one after that.
Whether it's May 22nd or June 12th.
The state would request June 12th. Trying VOP evidentiaries in the middle of the trial cycle is pretty tough for us to be able to get everything together.
I would agree with you.
All right, June 12th for the VOP. That's with subpoenas, so that'd be at 2:30 on that date, Madam Clerk? Okay. All right, very good.
Excuse me, Mr. Stone.
Yes.
Your Honor, whenever you get a chance, may I speak?
Well, talk to your lawyer first before you talk to me.
Much. I bless you. Your Honor, hello, my name is Antonio Rodeo Lee II. However, I want to say thank you for you and the state. I've changed my life physically, economically, educationally, and spiritually. I've been paying off this probation. I fixed myself in every way that rehabilitates you for probation. And I can't name a handful of people that honestly coming from my background, have done that. Got a job, I have a child on the way, I'm married at my age. I'm focused, I take care of family, and I'm devoted to be right, and only right. So whenever you make your choice, however you make your choice, I leave it in your hands, Your Honor. Just like I speak as I understand you. That's all it is, Your Honor. Regardless of what my background says, it isn't me. Look at my future, it's bright, very. Thank you, Your Honor.
You're welcome, sir.
I can do that, right? Okay, thank you.
All right,
I'm
thank
ready
you.
to go.
All right, yes, sir.
Thank you. Have a blessed day.
You too, sir.
Thank you, Your Honor.
Next is Tommy Lawson.
Your Honor, this is Tommy Lawson. He is here today for entry of a plea. At this time, Mr. Lawson is executing the plea agreement to resolve both of these cases. Let me put today's date, it's 14/4. In 25 CF 468, Mr. Lawson would enter a no contest plea as charged. In 25 CF 467, he would enter a no contest plea as charged. The agreed upon disposition is that Mr. Lawson will be placed on, well, let me break it down briefly. 25 CF 468, there are two counts. Count 2 is possession of paraphernalia. Mr. Lawson will be sentenced to time served on that count. Count 1 is possession of a controlled substance. Mr. Lawson would be placed on 12 months of probation. On that case, special conditions of that supervision are that he will do a substance abuse evaluation and any recommended follow-up treatment. He will perform 24 hours of community service. He will pay $615 in court costs, a $100 public defender fee, a $50 application fee, and that supervision would automatically early terminate at 6 months if all of his conditions are met. And he also must maintain employment as a condition of supervision or show proof that he's looking for a job. In 25 CF 467, Mr. Lawson will be placed on 12 months of probation concurrent to the 468 case. He would pay $1,515 in restitution to Marie Robert, common spelling. He would be assessed $615 in court costs, a $100 public defender fee, and that would also automatically terminate at 6 months if all conditions have been met. May I approach?
Granted.
And there would be a withhold of adjudication.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
All right. You heard what Mr. Klein said, and you signed the written plea form?
Yes, sir.
And how old are you and how far did you go in school?
I am 50 and I have a bachelor's degree, Your Honor.
You able to read and understand the plea form?
I do, yes, sir.
Did you do that before you signed it?
Yes, sir, I did.
And it's what you read, what Mr. Klein said?
Yes, sir, Your Honor.
Do you understand you're pleading no contest to the announced charges?
I do, Your Honor.
And that says to me that you believe the state has the evidence necessary to prove your guilt, and you're not going to contest that.
That is correct, Your Honor.
And do you understand also by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt? And in this case, adjudication will be withheld. You'll be sentenced to time served on the misdemeanors and 12 months of probation with the evaluation, recommended treatment, community service. The fees and costs are announced, the restitution, and you can terminate at 6 months if all of the conditions are completed, and you must maintain your employment as a condition of your supervision. Is that your agreement? Mr. Klein's answered all your questions about the plea and how it affects you?
Yes, Your Honor.
Satisfied with how he's represented you?
I am, yes, Your Honor.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Good luck. Okay. Very nice. Yes, sir. Your Honor, Ms. Loomis is signing a plea agreement right now. She will be admitting the supervision to this court. She'll be admitting the violation in this particular instance. The agreed upon disposition is that Ms. Loomis will be sentenced to 24 months in the Department of Corrections with credit for all time served. Her supervision would be revoked and terminated. There would be a $100 cost of prosecution, $150 in public defender fees. She has previously been adjudicated. The main issue with Ms. Loomis, Your Honor, is the credit. This was passed from last week, so I could do some looking into the fact that she had 2 different cases at one time. Did the court get a chance to review the memorandum of law that I had filed?
Yes.
If I could approach with the plea agreement, though, so the court can run through the colloquy with that before addressing the credit.
Yes.
And Your Honor, this is a downward departure for the purposes of a legitimate uncoerced plea bargain. I thought I gave you one. Yeah, I thought I did. Maybe I did. Hold on.
May I approach, Your Honor?
Granted. All right.
As to the credit, Your Honor, I mean, I laid it out as best as I could in the memorandum. It definitely appears to me as if there was significant confusion, probably between everybody involved back when this was going on. Definitely Mr. Niddle's two bond motions he filed referenced both case numbers. I really think the memorandum speaks for itself. We're simply asking the court to award Ms. Loomis credit for any time she spent in custody from July 15th, 2023 to this period, any time she spent in the Okaloosa County Jail, because it's really uncertain whether she was legally in custody on the 1594 case. She was definitely in custody on the 369 case. In reviewing the case law for today, really even if the court just says I'm just whatever she's legally entitled to, if there's an appeal, if it's reversed, it's going to be reversed for an evidentiary hearing, which is going to require testimony from Ms. Barrickman, testimony from Mr. Niddle, all sorts of issues that would come up. And at this point, I think equity alone would justify the court awarding all credit from any time that she spent in the county jail from July 15th, 2023 to the present. it's just one of these freaky situations where somebody gets arrested on one case and then nobody actually goes back and non-pro-tuncs a revocation, which is essentially what I'm asking the court to do here from July 15th forward. And so the court's aware. My calculations on her credit means she's still going to be in custody for another 7 or so months. So this is not a situation where we're asking the court to award a ton of credit so she can get out now. I don't expect her to get out now. I know Ms. Loomis wants to ask the court if the court would consider the 4 months that she spent at Phoenix House toward that credit. My position is I don't know if she is legally entitled to that. I think equitably speaking, she should get the credit from July 15th forward. I'll leave it up to the court on whether the court wants to award the credit for the time she spent at Phoenix House. She has not been out of custody since December of 2023 is my understanding.
Yeah, that is correct. I went from an institution to a DOC facility and was violated on site and taken from another jail to this jail, and I've never not been in custody. If you could consider that, I would greatly appreciate it.
What's the state's position?
We don't object to any of the facts or the timeline laid out in the memorandum of law. We think that she's entitled to all the time that she's legally entitled to. But with respect to the 4 months for the Phoenix House, we would object to that. We believe that she should receive time for the period that she was incarcerated. I do agree with Mr. Klein's statement of equity. That appears to be, to me, the correct way to handle this time. So I would.
Okay, I'm going to be clear. So you agree that she's entitled to the time on the 1594 case, even though the bond wasn't formally revoked?
Correct, Your Honor. I mean, she was in custody. It should have been changed, and she should have been being held on that and receiving time.
Right, because she was being held without bond on the other one, and that bond wasn't revoked, so she should be entitled to all that time.
Correct, Your Honor.
Okay, so Mr. Kleins, all that time would be granted. Now, I'll listen to arguments of why you believe and now as far as the time in the Phoenix House, that would be up to, I know the case law goes a variety of different ways on those circumstances. It's fairly clear that time spent, for instance, in the Florida State Hospital, you're legally entitled to that because you're absolutely positively not free to leave.
That's correct.
And on the extreme other end, voluntary inpatient treatment, the law is fairly clear you're not entitled to that at all. In between there falls things like the Phoenix House and other places, and the court's understanding the prevailing case law is it's in the court's discretion that circumstances have to be presented which would support that the court should grant credit under the circumstances presented. Does that sound like a fair representation of the case law?
That does, Your Honor, and that's why I hate anytime I have clients asking me, because I'm like, the case law's all over the place on this. I mean, it really is. She did go from a bars to bed situation straight from the county jail to the Phoenix House program, and she was there until her discharge, at which point I believe she was taken into custody and transported back.
Correct.
So our position would be that she was in a Department of Corrections facility. It was an inpatient facility. She never left the facility. She was basically discharged based on conduct within the program. It's not like she absconded from the program. So our position and the request would be the court grant her the time that she was in Phoenix House at the time. Is there anything else you want to say? Okay.
Response.
I don't know if Phoenix House is a Department of Corrections facility. I'm not aware of that. I just quickly tried to look that up. I don't think it is. It's a nonprofit organization. The reason why we're objecting to this is that Phoenix House was given as I think a third or fourth break for Ms. Loomis. She scored the Department of Corrections time. She asked for Phoenix House, and she was given Phoenix House in lieu of Department of Corrections time. She is, as I said, she's receiving a downward departure for this sentence to go and serve it at 2 years. We feel as though the court should use its discretion to deny that request to add the 4 years to the credit that she's receiving. We don't feel as though that she is entitled to that. That's our position, Your Honor.
Any last minute arguments on that?
I do have something to say, if that's okay.
Well, talk to Mr. Kleins first.
Ms. Loomis just wants to advise the court about the realities of being in the Phoenix House program. I don't think I know I can't speak to that. So.
Yeah, I'll try to keep it very brief, but it is factual that it is a DOC-run facility. They remind us of that every day that we're there. There is an on-site probation. In order to even go to that program, you must be on probation because it is a DOC-run facility. I would assume that the state would have known that, but everybody makes errors. That, and I would like to just say to you, sir, that I did ask for that and aiming to put my best foot forward. I did learn some things from that program. It was a little bit more than I had expected. There was a lot of things going on, but that's neither here nor there. I just ask that you would recognize that. And if it's in your power to do so, sir, if you please grant me that time that I've been in also, so I can get home to my family and continue my life.
I understand the arguments being made in that respect, and I've reviewed again the record, and based upon the record that I've reviewed here, the court declines to exercise its discretion to award that time based upon the circumstances presented for the defendant's termination from the program. The court will award all the time based upon the memorandum of law and the state's concession on the revocation of the bond conditions in the 1564 case. So, Mr. Kleins, what I'd like you to do, just to be sure the record's clear and we don't get any kerfuffle about that, is I'd like you to collaborate with Mr. Gomez and produce a separate order which says very clearly what the court's ruled on your motion and your memorandum, that she's entitled to all of that credit based upon the time and the over.
Does the court just want me to announce the dates now so it can be reflected on the minute sheet?
Well, that would work if you're comfortable with that.
Right. Yes, I do have the
Okay,
dates
all
right
right, let's do it that way.
Okay.
Madam Clerk, take the dates down and all those dates so that she gets all that credit.
So the credit in this particular situation is going to start on July 14th. That was her arrest date. Okay. She was bonded out of jail on July 17th. She was then rebooked into the county jail on August 2nd, 2023. And then she was released on October 9th, 2023. And then she was booked back into the county jail on December 21st, 2023, and was released to the Phoenix House program on October 9th, 2023. And then,
2024.
I'm sorry, yes, 2024, thank you. And then she was booked into the county jail here again on February 21st, 2025 to the present day. Now, there may be some credit when she was arrested in Marion County and transported up here. I don't have those dates. I think the jail will definitely know what those dates are.
It would be February 12th in the Marion County Jail until February 21st.
So you want me to notate that as well, the defendant shall receive credit spent in Marion County?
Marion County, yes, because she would have been taken into custody and pending transport up here on this violation. I don't know the specific date. I mean, Ms. Loomis just said it was February 12th, but the jail can confirm that. I'm going to give that to you.
All right. All right, so with that, raise your right hand. Do you swear or affirm testify truthfully in this matter under penalties of perjury?
Yes.
You can put your hand down. You understand you're admitting the violation?
Yes.
And in this case, you'll be adjudicated guilty, 24 months DOC, credit for the time served that we discussed, which doesn't include the time in the Phoenix house. Revoke and terminate your probation with your costs, outstanding cost, and the additional costs. Once you're released, I'll give you 24 months to pay your costs after you're released. Mr. Klein's answered all your questions about the plea and how it affects you.
Yes.
Satisfied with how he's represented you?
Yes.
Find the plea to be freely and voluntarily entered into, and will accept the plea with the credit as we have announced.
Your Honor, while there's a moment, may I approach with a score sheet on DeAndre Tarver?
Yes. Thank you. All right.
Philip Lozinski.
Your Honor, this is Mr. Lozinski on a motion to reduce bond. Did the court get a chance to review the records that we provided?
On the motion to reduce bond,
Yes, Your Honor. If we could approach this briefly, I can explain.
and then also in your motion to declare,
Well, that's not noticed for hearing today.
then I don't know what records you're referring to.
If I could approach.
Granted.
I just didn't want to proceed without the court being aware of this. So, Your Honor, when Mr. Lozinski was arrested, he was arrested in Minnesota. He was transported down here. The bonds, as currently set, are laid out in the motion. I will apologize to the court. In reviewing this yesterday, I realized I didn't put a dollar amount in here. What we would be asking the court is to reduce the currently set $25,000 cash or professional bonds for the use of a computer to $10,000 signature bonds, and the two $25,000 cash or professional for transmitting material to $5,000 signature bonds. Count 6, the state, or I'm sorry, count 5, the state would agree to reduce that to an ROR bond. But based on Mr. Lazinski's, the fact is he lives with his brother at a house in West Concord, Minnesota. He's lived there for about 5 years. He was arrested one time in his life in 2011 for possession of marijuana. He's already been ordered to wear a GPS monitor. He does not object to the condition of that bond. He is simply asking the court to consider reducing these so that he may be released, so he ideally would return to Minnesota to resume his cancer treatments while this case is pending. We have not taken depositions in this matter yet. This is a January arrest, so and that's pretty much our position. Is the reason for the request here is based on Mr. Lazinski's medical situation. It does not appear that anybody is contesting that he actually is in treatment. So I'll pass it to Ms. Barrickman for her argument.
Judge, given the circumstances, medically, we don't have an objection to reducing the monetary amount, but we do believe cash professional bonds are appropriate in this case. We would ask for a $5,000 cash professional bond for each solicitation or transmission count and would have no objection to the ROR on the two-way communication device. We do have concerns about releasing the defendant to the same conditions where he committed these crimes and pretrial services ability to monitor him from Minnesota, especially due to the extended nature of these charges. If the court looks at the information, they began in December of 2023 and the chat spanned through the beginning of May of 2024. So there was many months when this was going on. He does score 52.8 months in the Department of Corrections presumptively with a max of 25 years. We would ask for GPS, no contact with minors. It's currently set as no supervised contact with minors. Do not be where they congregate, no internet or internet capable devices if the court is inclined to reduce the bonds.
Your Honor, Mr. Lazinski has no objection to the special conditions requested from the state. I would point out, I did ask in the motion, if he is going to be in Minnesota, if the court would modify the weekly in-person pretrial services reporting to weekly phone-in reporting. Mr. Lazinski does not have pretty much any money. He would request if the court feels that a cash bond is appropriate in this case, he would request that the court set a $500 cash bond. My concern is that he lives so far away and he really has no ties to the community. Even though he'd be on a monitor, the problem would be him finding a bondsman willing to take a bond for somebody essentially on the other side of the country. So that's the main reason why if he was a local resident, I'd probably be saying, yeah, give him a $5,000 cash or professional bond and he can post it. The only reason I'm picking $500 is because it's an obtainable bond, I believe. I don't even know if he could afford it right now, but it would at least put some kind of buy-in into the system here. If he fails to appear, he's going to forfeit that money. I don't think he's going to fail to appear. He has no record other than that arrest 14 years ago. So
I mean, those are all the factors under 903-046 I'm supposed to consider.
I know, Your Honor. And I got to play the hand I'm dealt, though. I mean, he's from Minnesota. It is what it is.
You know.
He would be on a monitor.
And of course, nowadays Minnesota is not as far away as it was when I was a kid, but it's still pretty far away.
I would have moved. It's been a long time since I've flown into Minneapolis, but it's probably a couple-hour plane ride from Orlando for sure.
A lot farther away in a 1964 VW than it is now.
100%. If I tried to drive up there in my first car, it would take a while, for sure.
Ms. Berry.
I don't have anything further, Judge.
And so you're asking for 5,000 times 4 and an ROR on the two-way.
That's correct, Judge.
Right. And I understand your arguments, Mr. Kleins, but I think having the bondsman, which then puts the bondsman on the hook should he fail to appear, is, you know, even given the circumstances and considering the impact of the circumstances on the, be very candid, the public coffers if the court doesn't modify this. At the same time, the court's strongly concerned about the 903-046 factors and modifying that without consideration and having a bondsman on the hook who would then be responsible is one of the mitigating factors the court would do in making the modification. And so the court really finds that weighing those things together, the court finds that $5,000 on each of the 4 counts is appropriate. I'll modify the conditions, like you said, to weekly reporting by phone and continue the GPS and the other terms and conditions. And I want you to collaborate with a written order on that instead of a release on the...
Absolutely.
And that'll be the terms and conditions. And because of the situation, I want to be sure that also that the order says that pretrial will confirm his residence.
Okay.
And that he's welcome back there, and that he can't change his residence without permission and confirmation by pretrial as well.
Yes, sir.
Okay?
All right. Your Honor, Mr. Lazinski is already on the May 12th docket. If we could just leave this on the May 12th docket, sir.
Yes, sir.
All right, Mr. Lazinski. We'll probably get that order to the court tomorrow, Your Honor.
That's fine, sir.
Eric Lucas.
Your Honor, this is Mr. Lucas. He is signing a plea agreement to resolve the violation today. Today's 4/24. This time, Mr. Lucas would be admitting the violation. The agreed upon disposition is that Mr. Lucas, his supervision is going to be modified. His term date is next November 2026. So for the next 6 months, Mr. Lucas is going to be placed on community control. And just reading the plea agreement, I did not write the term community control, but that's what the agreement is. And Mr. Lucas's supervision will be converted so that the next 6 months he's on community control, followed by the remainder on regular probation. Reimpose all prior conditions of supervision. There's a $100 cost of prosecution, $150 in public defender fees. He's previously been adjudicated. May I approach?
Granted. Raise your right hand for me, please, sir. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you can put your hand down. You heard what Mr. Klein said, and you signed the written plea form.
Yes, Your Honor.
Do you understand that you're admitting the violation?
Yes, Your Honor.
And that says to me, Judge, I violated my probation just the way the affidavit and report says I did.
Yes, Your Honor.
You understand by making this admission, you're waiving your right to a trial where the state would have to prove you violated.
Yes, Your Honor.
In this case, you were previously adjudicated guilty. Your supervision will be modified to the next 6 months on...
I know, and I didn't want to have to put it on there after everyone had signed it and have everybody initial it. That's my fault. I just left off the term community control. But he's aware that this is going to be community control for 6 months.
Okay. To CC, and otherwise, all the other conditions and the end of termination are the same.
That's correct, Your Honor. And his term date is November 13th, 2026.
All right. Mr. Klein's answered all your questions about the plea and how it affects you.
Yes, Your Honor.
Satisfied with how you've been represented.
Yes, Your Honor.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you, Your Honor. Thank you.
Gary Mays.
Go ahead and sign it. Your Honor, this is Jerry Mays. He is signing a plea agreement to resolve this violation. At this time, Mr. Mays is going to admit violating supervision. The agreed upon disposition, it's 424, is that Mr. Mays is going to have his supervision modified to reflect a 30-day county jail sentence from the date of his arrest on this violation, which is March 21st, Today's obviously April 24th, so the state would stipulate on the record that Mr. Mays has served that entire 30 days. The rest of his supervision is going to remain the same. All of the prior conditions of supervision will be reimposed, reinstate to his original term date, which would include a GPS monitor that has to be attached prior to his release from custody, $100 cost of prosecution, and $150 in public defender fees. If I may approach, and he has previously been adjudicated. If I may approach.
Granted. Raise your right hand, please. You swear affirm to testify truthfully in this matter under penalties of perjury. All right, you can put your hand down. You heard what Mr. Klein said, and you signed the written plea form?
Yes, sir.
And you understand that you're admitting the violation?
Yes, sir.
You're waiving your right to a hearing where the state would have to prove it?
Yes, sir.
And in this case, your supervision is modified for the 30 days in county jail, credit for time served from the arrest, and reimpose all of the other terms and conditions, and the state stipulates you've served your time. Mr. Klein's answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into. I'll accept the plea. Thank you.
Thank you. All right.
Next will be David McLeod.
Your Honor, this is Mr. McLeod. Last week, he had he had entered a plea agreement with the state for 8 years in the Department of Corrections to resolve this. It was continued to today so that I could try to look into his credit issue. Early this week, on Monday, I filed a copy of the arrest report down in Palm Beach County, which references a violation of probation arrest. The way I read it, looks like an arrest to me on page 1 of the notice to appear. Yesterday, I filed something we call the booking sheet. I talked to the Palm Beach County Sheriff's Office yesterday. They call it a face sheet. That's actually what it says at the top of page 1.
Booking face sheet.
Yes, sir. It's not the first time I've heard face sheet. This is the first time I've ever heard the term street violation, which is referenced on page 2 of that face sheet. At the very bottom of this page 2, it says street violation, which apparently is a term in use down there, because when I talked to the Palm Beach County Sheriff's Office, the deputy I talked to at Central Records also referred to it as a street violation. I tried to look it up, and there's really not there's no case law that I could find in Florida that uses that term. Obviously, it's not a legal term. The way I take it is, it sounds like what they're referring to when somebody's arrested on new charges, and then at the same time, there's a probable cause arrest on the violation of probation. So that's kind of how I take it. However, that face sheet also specifically uses the word hold, but the issue, as far as I can see it, is I don't know if it was a hold, like a detainer, so to speak, which is not entitled to credit. Our position is that this was an actual probable cause violation of probation arrest effectuated by the Palm Beach County Sheriff's Office, and therefore Mr. McLeod is entitled to credit from that arrest date in May of 2021 toward any subsequent sentence here in Okaloosa County. Mr. McLeod definitely has previous 48 months in the department on this particular charge, so he does have 4 years of prior prison credit he's legally entitled to for sure in this case. The issue the court has to decide really is, does the phrase street violation, I mean, I didn't lock anybody down to how they define it down there, but it seems to me and appears to me they can say it's a hold all they want. The Palm Beach County Sheriff's Office conducted a probable cause arrest on this violation at the time that he was arrested on those charges in Palm Beach, and therefore Mr. McLeod is entitled to all that credit from the arrest date in Palm Beach County on this case.
Well, and our VOP report, and I just say our because I'm talking about Okaloosa counties to discriminate from Palm Beach, says that, how a violation occurred.
That's correct. That's the basis for this violation. is that
Right. It says that he was arrested on 5/26/21 for the new law offense. And but what it doesn't say specifically let me see. The Okaloosa County subsequently issued a warrant on 6/8 on that violation. So I guess I'm not clear that there was actually a PC arrest on the VOP.
And I'll kind of always fall back on that. Arrest warrants command arrests, you know? And so our position is if there's a command of an arrest and the state knows where an individual is, especially if that individual is in custody, it behooves the state to go execute the warrant. I know I tend to be, kind of spitting into the wind with that argument, but our position is, and you're correct, Your Honor, I'm looking at that warrant from Okaloosa County issued in June of 2021, and the date and time of service of the warrant is March 27th, 2024. Mr. McLeod has been in the county jail for sure for that last year here, so he's definitely going to have at least 5 years of credit. Our position just is that because those charges in Palm Beach County violated this supervision, the arrest report itself from Palm Beach County, if the court looks at the first page, count one in that, on that arrest paperwork is, and I seem to have misplaced it. I've got all sorts of papers.
The first page, I'm looking at it, the first page, we're looking at the booking face sheet, which is 2 pages, and it's listed at the top, page 1 of 2. And at the bottom of that, are you following along, Ms. Barrettman, where I am?
Yes.
At the bottom, it has count 1, and it just says count 1 3 times, so I don't know. That appears to be the new charges. Page 2 of 2 at the bottom says probation violation, street violation, VOP, DOC, Okaloosa County case, and it refers to the Okaloosa County case. So it does appear that they made a PC arrest on the VOP, Ms. Bergman. That appears what the booking face sheet says, right? And I know there was a period of time when probation was issuing warrants even after a PC arrest anyway. I don't think we're still doing that once we have a PC arrest on the VOP. They're still issuing the violation reports because that's how our file gets documented, if that makes sense. But they're no longer asking for a warrant to be issued if the arrest report clearly indicates they were PC arrested.
Judge, it does appear that is what is on page 3 of 5 in reciprocal discovery, yes.
And so I believe based upon that it would be appropriate to provide for credit in this case for this sentence from the 5/26/21 on the sentences being provided based upon the reciprocal discovery that's been provided. Because it seems clear that Palm Beach arrested him on a PC VOP. It specifically refers to our case number. Now, I'll listen to arguments contrary.
Judge, we would stipulate he's entitled to all legal credit, and if the court, we'd leave it to the court's discretion.
All right, so the court will find that he's entitled to credit on this violation from 5/26/21. Now, I don't know about any prior credit, but on this violation, he's entitled to credit from 5/26/21.
And, Your Honor, he was sentenced to the Department of Corrections on this case to 48 months. I mean, obviously, he didn't do the full 48, so our position would be that he's entitled to whatever prior prison credit he also has.
Oh, sure. Once again, I'm not
Okay.
suggesting that that's the only credit he's entitled to.
Sure.
But on this violation arrest, he's entitled to credit from 5/26/21.
Okay, I just wanted to clear that up, okay? He's previously been adjudicated, Your Honor, so.
Correct. All right, so with that, then the court will impose the sentence under the plea agreement with the understanding of the credit the court's determined. And 24 months to pay his fines, fees, and costs.
We'll send him back.
Next is Theodore Moroni.
This is Mr. Maroney in 25 CF 447. He's here on a motion to reduce bond. The state is agreeing to reduce the bonds as we requested to $10,000 per count, so he would have a total of $150,000 in cash or professional bonds. Count 16 would be an ROR bond. Ms. Barrickman had requested special conditions of supervision to be as follows. I'm sure she'll chime in if I miss one. A GPS monitor to be attached before release. Mr. Maroney would object to that particular special condition. Also, that he have no unsupervised contact with minors. He has no objection to that. That he have no internet-capable devices. He has no objection to that. That he not be using controlled substances while out on bond. He has no objection to that. Her other request is that he not have any alcohol consumption. Mr. Maroney does object to that, just based on the fact that he's an adult. As he stands here, he's innocent. So the reason why he's objecting to the GPS monitor is that Mr. Maroney is a pool repair individual. So he works in environments, especially coming up, it's going to be hot and sunny. He doesn't want to have a bulky ankle monitor on for essentially business purposes. It's just, he's afraid it's going to get in the way of work, I believe. So we all agree on everything except for the GPS monitor and the no alcohol, essentially.
Judge, may we approach?
Granted.
You stay here.
All right.
One question? So she can pay my bills?
As long as you're not on the internet.
Okay, then I'm fine.
That would apply to you. But we'll turn it over to the court for the court's ruling on the GPS and the no alcohol.
Okay. The court will agree to reduce, based upon the stipulation, the monetary amount, so the other terms and conditions would remain in place. Why? Because those are the standard terms and conditions the court imposes under these sorts of circumstances. And it's fair and just for those bond conditions to be similar for similar crimes and similar circumstances. So the monetary amounts will be changed based upon the agreement, but the other conditions will remain in full force and effect.
Yes, sir. The special conditions that Ms. Barrickman was requesting today, I don't believe were previously ordered. So.
I thought they were.
No, they were not. And that's, I want to make sure I'm not saying the wrong thing here. I think I'm correct.
Let me pull the order.
Because the evaluation that was done prior to bonds being set dealt with mental health aspects of things.
It doesn't look like pretrial conditions were assessed on the original order. There was just an eval ordered.
That's correct.
Okay, so those other conditions are based upon the review performed by pretrial, and that's what's recommended by pretrial if you read the evaluation. So I'll include those special conditions based upon what pretrial said.
And Your Honor, we'll confer with Ms. Barrickman and we'll provide an order, given that this is kind of more involved.
Thank you very much.
But Your Honor, Mr. Maroney's case is on the May 12th docket. I can almost guarantee that the situation is not going to be ready for trial on May 12th if the court would entertain continuance.
Objections to a continuance?
No objection.
Matter will be continued. You want it the next trial cycle?
Yes, sir, Your Honor.
Madam Clerk? July 14th.
All right, so this is your next court date. Now, you might not get out to
Mr. McKinney, you need to approach.
Simply. Yeah, you're good. Okay? All right.
So I gotta wait before I get a bail bond?
Yeah, give it a day or so. Let's get the order up there. Okay? All right.
Next is Chad Mott.
Yep.
Do you want to sign this? No. Your Honor, this is Mr. Mott. He's going to be signing a plea agreement right now to resolve the violation in this case. You want to sign it? Well, then sign it. So at this time, Mr. Mott is going to be admitting the violation of supervision as 42425. The agreed upon disposition is that Mr. Mott would be sentenced to 6 months county jail with credit for all time served. His supervision will be revoked and terminated. Mr. Mott did plead this down to 2 first-degree misdemeanors, so he would be adjudicated of these misdemeanors. The intent of the parties here, Your Honor, and so the court's aware, Mr. Mott has 5 pending misdemeanor cases, a couple of new laws, a couple of violations. Those are already set for the May 12th docket in county court. The offer that I have been relayed from one of my coworkers in my office is that the state's offer in those cases is 270 days, and that offer is firm and is not going to change. The intent is that this would run concurrent to whatever sentence is imposed. I know the court can't run something concurrent to something that doesn't exist yet, but I wanted to be clear on the record that the intent here is that Mr. Mott's going to probably end up serving a total of 9 months on some county court cases, but this 6 months we wrapped into it.
So you're asking the court to say the court has no objection to this sentence being concurrent to any other sentence that may be imposed?
Correct.
And is state agree to that?
Yes, Your Honor.
Okay.
May I approach? And this is just, this is misdemeanor, so there's no solution.
All right. Raise your right hand. Swear or affirm testify truthfully in this matter under penalties of perjury.
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Klein said. You understand you're admitting the violation.
Yes, sir.
Okay. And that says you violated just the way the affidavit report says it did.
Yes, sir.
All right. And you understand by doing that, you're waiving the right to a trial where the state would have to prove your violation.
Yes, sir.
And in this case, you'll be adjudicated guilty, 6 months county jail, credit for all time served, revoke and terminate your probation. You have your fees and costs that you'll have to pay, and I'll give you 180 days after your release to pay after that. No objection to this sentence running concurrent with any other sentence that may be imposed against you in your other cases.
Yes, sir.
Is that the plea you wish to make?
Yes, sir.
Court find the plea to be freely and voluntarily entered into and will accept the plea.
Good luck, Chad, okay?
Thank you.
Good day, sir.
Next is Eduardo Ojeda.
Your Honor, this is Mr. Ojeda in 24 CF 1312. We will enter a denial today. He does have a new law violation in 25 CF 660. That is on the May 15th arraignment docket. So if we can pass the 24 CF case to track with the 25 CF case, and we'll have Mr. Ojeda back on May 15th.
Let's put this case on the arraignment docket with that case, please.
All right. Yes, sir.
Mr. Koch.
Good afternoon, Judge.
Good afternoon, Mr. Koch.
Jeremy Ray.
Your Honor, this is Mr. Jeremy Ray. We have him for 23 CF 1899. Also on the docket is the 25 MM 841 case. If I may have a brief moment, Your Honor.
Yes, sir.
Judge, this will be a change of plea of no contest. In the 23 CF 1899, it's a violation of probation. We'll be admitting the violation, prior adjudication of guilt, 135 days in the Okaloosa County Jail with credit for time served. There's the $100 cost of prosecution, $150 in court costs, and probation will be revoked and terminated. In the 25 MM 841, adjudication of guilt, credit for time served, $270 in court costs, and $100 in defense costs. If I may approach with a signed plea form and score sheet.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right. Now, you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes, sir.
All right, and you've got two things going on today, right? You got your VOP and you got your new charge.
Yes, sir.
We're taking care of them together, but they're two separate cases, right? Okay. As to your VOP, you understand you're admitting the violation.
I do.
And that says to me that you agree that you violated the way the affidavit report says you did.
I do, Your Honor.
And you understand by making this admission, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
As to your new charge, do you understand you're pleading no contest to the new charge?
Yes, Your Honor.
And that says to me you believe the state could prove your guilt and you're not going to contest that.
Yes, Your Honor.
Do you understand you're waiving your right to a trial where the state would have to make that proof?
I do.
In this case, on your violation, you're going to be adjudicated guilty, 135 days county jail credit for time served with your fees and costs, and your probation will be revoked and terminated. On your misdemeanor, it's credit for time served with your fees and costs. It's 180 days after your release, enough time to get your fees and costs paid.
Yes, Your Honor.
Has Mr. Koch answered all your questions about the plea and how it affects you?
Yes.
I'll find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Correct, credit time, sir, you will get. Yes, sir. You're welcome.
Okay, no worries. Dylan Riggins?
Judge, this is Mr. Dylan Riggins in 25 CF 169, Your Honor. Judge, we'll be entering a denial this afternoon and request that second date in June with subpoenas, Your Honor.
All right. Madam Clerk? June 19th at 2:30 with subpoenas.
That's our next court date. Yes, sir.
Next is Arthur Rolling.
Judge, this is Mr. Arthur Rolling in 2020 CF 1558. If I may have a brief moment for a single.
And just, you've got cost of transport here too, Mr. Koch.
Yes. Can I get that figure, Your Honor?
217.50.
Thank you, Your Honor. I'm going to make that adjustment now, Your Honor. I apologize.
Your Honor, may I have a moment with Mr. Koch?
Additional cost of Judge, I first want to just make, I know the court is aware that my client did return from the Florida State Hospital, and I do have the discharge evaluation, finding my client competent to proceed, Your Honor. With that being said, we'll be entering.
Does the state accept the report?
Yes, Your Honor, the state accepts the report.
The court makes the determination that the defendant is presently able to proceed.
Thank you, Your Honor. Arthur Rowland today will be admitted to the violation. This will be an adjudication of guilt and prior adjudication of guilt, Your Honor. It is 39 months, Department of Correction. The state attorney does stipulate that all credit has been served, so essentially this is a credit time served offer.
Yes, sir.
There is $100 cost of prosecution, $150 in defense costs, and then there's the $217.15 for the cost of transportation to the Okaloosa County Sheriff's Office. And the probation will be revoked and terminated.
That'll work.
If I can approach with the plea form and the sign.
Is 24 months enough time to get those fees and costs paid?
Is 24 months, all those costs we talked about, is 24 months once
I'll
you're.
get it as soon as you need it.
24 months will be fine, Judge, thank you.
All right, raise your right hand for me, please.
Yes, sir.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you put your hand down. You heard what Mr. Koch said and you signed the written plea form?
Yes, Your Honor.
Do you understand you're admitting the violation?
Yes, sir. Yes,
Do you
sir.
understand that by admitting the violation, you're waiving your right to a hearing where the state would have to prove you violated?
Yes, Your Honor.
And in this case, you were previously adjudicated, and your probation is going to be terminated, and you'll be sentenced to 39 months in the Department of Corrections, but the state stipulates that you've already served that time, and essentially this is a credit for time served sentence. Do you understand? Mr. Koch answered all your questions about the plea and how it affects you,
Yes, Your Honor.
and you satisfied with how Mr. Koch has represented you. The court will find the plea to be freely and voluntarily entered into and will accept the plea. Okay. Thank you very much. Good day.
Best of luck.
Next will be Tommy Ross. Tommy Ross. Okay, Satchel Williams. Okay, where's Ross?
Judge, this is Mr. Sean Sasser Williamson in 23 CF 381 and in 23 CF 411, Your Honor. If I may have a brief moment, Judge. Thank you, Your Honor. Your Honor, this will be an admission, maintain the withhold of adjudication, reinstate all original conditions and costs. There's the $100 cost of prosecution, $150 in defense costs, and we will be adding an additional 40 hours of community service. And I would request if my client had the option to buy out partial or all those hours, if I may approach the score sheet.
State.
That is the state's agreement, state has no objection to that.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes, sir.
You understand that you're admitting the violation
Yes, sir.
and waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, your adjudication will remain in, the withhold of adjudication will remain in place. You'll be returned to all your original conditions with an additional 40 hours of community service and the additional costs.
Yes, sir.
Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea and will provide for you the ability to pay out your community service.
Yes, sir.
Thank you, Judge. All right, Sean.
Thank you.
Yes, you're welcome.
Paul Pierce.
Judge, this is Mr. Paul Smith Jr. in 25 CF 223. If I may have a brief moment, Your Honor. Judge, Mr. Paul Smith Jr. will be entering a no contest plea to count 2. Counts 1 and counts 3 will be no pros, but in count 2, this will be an adjudication of guilt, 36 months of standard probation. There's a $40 per month cost of supervision, parenting classes, the 24 hours of community service, no drugs without a valid prescription, no alcohol, random UAs, random breath tests, must successfully complete Jada House, bars to bed. So you'll be getting released bars to bed. Correct. Comply with any and all DCF recommendations, and contact with the children is allowed per DCF rules. If I could have just a brief moment, Judge. Plea form and score sheet.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form.
Yes, sir.
How old are you?
36.
How far did you go in school?
11th grade.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what Mr. Koch announced what you read in the form?
Yes, sir.
Do you understand by this agreement that you're pleading no contest to the announced charges?
Yes, sir.
And that says to me you believe the state has the evidence necessary to convict you and you're not going to contest that?
Yes, sir.
Do you understand by making this plea you're waiving your right to a trial by jury where the state would have to prove you guilt?
Yes, sir.
And in this case, you'll be adjudicated guilty on count 2 and have 36 months of probation with the fees and costs that were announced, and also the community service, no substances without a prescription, and random testing to confirm that, and that you're going to go from jail to JADA, and you got to complete JADA, and you've also got to comply with any DCF or FFN rules regarding their cases and contact with the children,
Yes,
in addition to the standard conditions of probation. Do you understand?
Yes, sir.
Is that?
Oh, I'm sorry.
No, go ahead.
So going from jail to Jada, they have to come get me, or I just have to report to Jada? Because I was accepted. I can go myself, or do I have to wait for them? Because I could report.
I don't know how they transport, but you've got to go directly from jail to JADA.
Okay.
And just to follow, Judge, I'll be notifying Jada House that he's ready for pickup, of course, after we accept this plea.
Okay. And with that, has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how Mr. Koch has represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
This will be Mark Snyder, DA.
Right here, Mr. Snyder. Judge, this is Mr. Mark Snyder in 25 CF 130. Good afternoon, Mark. Take your time.
How you doing, Your Honor? Sorry, I gotta clear my throat.
Good, thank you, Judge. Judge, the court order evaluation was completed. Report date of March 29th of 2025. It was Dr. Zeman's recommendation that my client is incompetent to proceed in commitment to the Department of Children and Families, Your Honor.
What?
Does the state accept the report?
We do, Judge.
All right. And Dr. Zeman, it does indicate that that's the least restrictive setting. So the court will make the determination the defendant is not capable of proceeding and will commit him to the Department of Children and Families for restoration at this time. All right.
Thank you. And Debbie, could you hold him and help him out there? I'm done if possible. Thank you.
This will be Larry Starkey.
Yes. And Mr. Koch, just to remind you on all counts, on those cases, my policy is going to be from now on, I'm setting all of those cases for a review at 6 months, just because.
Yes, sir.
You know, because we have a couple of those cases where we didn't get a review, and if it's on the docket, at least we're able to set them. So, Madam, on all those cases where we're making that determination and a commitment, I'm setting them automatically for 6 months just as a status. That way nobody gets lost.
Yes, Judge. Thank you. Judge, this is Mr. Larry Starkey in 23 CF 1465. If I may have a brief moment.
Yes, sir. Yes, sir.
Judge, this afternoon we'll be admitting to the violation. It'll be adjudication of guilt, prior adjudication. Credit for time served, $100 cost prosecution, $150 in defense costs. Probation will be revoked and terminated. If I may approach with signed plea form.
And we also have a cost of transportation of 90.75.
Thank you, Judge.
And I'll give you a second to explain that to your client.
Thank you.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. You can put your hand down. You heard what Mr. Koch said and you signed the written plea form.
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that says to me, Judge, I violated just the way the affidavit report says I did.
Yes, sir.
In this case, and you're waiving your right to a hearing where the state would have to prove that.
Yes, sir.
In this case, your adjudication of guilt remains outstanding. You credit for time served with the fees and costs that were announced. Your probation will be revoked and terminated. Is 18 months enough time to get all your outstanding fees and costs paid? Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
You are satisfied with how he's represented you?
Yes, I am.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
We got Tommy Ross.
Thank you. Judge, this is Ms. Tommy Ross in 23 CF 2063. If I may have a brief moment, Judge.
Yes, sir. Yes, sir, and the court's aware of the report that was filed yesterday and any issues with the report.
No issues from the defense, Judge.
State.
No issue from the state.
Okay. And you may proceed, Mr. Koch.
Thank you, Your Honor. This will be an admission this afternoon. It'll be an adjudication of guilt, 100 days in the Okaloosa County Jail with credit for time served. There's $100 cost of prosecution, $150 in defense costs. Probation will be revoked and terminated. If I may approach with a signed plea form and score sheet.
You may, sir. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
And do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
That says to me that you violated your probation just the way the affidavit and report says you did.
Yes, sir.
Do you understand by making this admission, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And in this case, you'll be adjudicated guilty, serve 100 days in the county jail, credit for all time served with some fees and costs, and your probation will be revoked and terminated. Is that your agreement?
Yes, sir.
All right. Is 180 days enough time for you to get your fees and costs to pay?
Yes, sir.
Okay.
I do, I have SSI. Can any of the court costs be waived? I'm on limited income.
Yes, ma'am. I can't lawfully waive any court costs.
Okay. That's fine, thank you.
So you need more time than that, you think?
If you could give me a little more time, I said, I'm just on limited
How
income.
about 18 months? How about
I'm
that?
still paying back some time from when I was in jail, so
Okay, I'll give you 18 months.
Thank you.
Okay. Mr. Koch answered all your questions about the plea and how it affects you?
Yes, he did.
And you're satisfied with how he's represented you?
Yes, very much so.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you.
You're welcome, Ms. Ross. Good luck.
Next will be Matthew Strong.
Judge, this is Mr. Matthew Strunk in 23 CF 2795, Your Honor. Judge, if we can get this case also placed on the June 19th date with subpoenas, Your Honor.
All right. State.
Objection from the state, Your Honor, we will accept that.
All right. It'll be set with subpoenas on the 19th.
Excellent. Thank you, Judge.
Thank you.
Have a good one.
Next will be Lewis Kuhn Ingram.
What about John Pope?
Sorry?
Pope?
He's in another institution.
Okay.
Could we address that case, Judge?
Yes.
Because I was a little confused too. This is John Pope in 24 CF 1626. November 7th of 2024, he was found incompetent and committed to Florida State Hospital, Your Honor. I saw him on today's docket, and I didn't see any paperwork saying that he was discharged or any further eval, so I was kind of confused too.
Well, it may just be a status then, because I'm looking, the order was November 7th of 24. Sounds about like
Gotcha.
6 months, so we don't have a report yet or anything like that.
Okay.
So no one's heard from anyone?
I have not, State has not heard anything, Your Honor.
Okay. All right. Well, and my review of the report, my review of the order is that he was sent to Florida State, right?
Correct, Your Honor.
So it would be about time for us to have something from them. So let's advance this to the June 19th docket for a status as well, and possibly by then we'll have something.
Yeah, Your Honor. Thank
Okay. All right. Sorry about that, sir. We're now focused on you. Mr. McKinney.
This is Lewis Kuhn Ingram in two cases, 16 CF 1777 and 14 CF 1589, each felony violations of probation. We've reached an agreement. The agreement calls for an admission, adjudication of guilt. He was previously adjudicated 90 days in the Okaloosa County Jail with credit for time served, revoke and terminate the probation. There is a $100 VOP fee in each of the cases for a total of $200, a total of $250 cost of defense, and there is a $58.05 cost of transportation. May I approach?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. And you put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes, sir.
Do you understand you're admitting the violation?
Yes, sir.
And by doing that, I understand you to say that, Judge, I violated my supervision the way the affidavit report says I did.
Yes, sir.
All right. You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
In this case, you'll be adjudicated guilty if you weren't previously. You're going to be sentenced to 90 days in the county jail, credit for all time served. Your probation is going to be revoked and terminated. You'll have the additional fees and costs plus your outstanding costs to have to be paid. How much time do you think you'll need to pay those?
Like a year?
Okay, a year to pay. Mr. McKinney answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Judge, may I call Jamontre Hendricks?
Demontre Hendricks, did you hear from the jail about Mr. Corbett?
I did. They're doing a shelter at 1, and then they're going to get on it right after that. with Mr.
Okay,
Corbett.
all right, good. Thank you, Mr. McKinney, for being on top of that.
Yes, sir. This is Jamontre Hendricks before the court in 23 CF 1260. We fixed the issue and make sure that everything's open in this case, the felony violation of probation. We have reached an agreement that's also going to include a plea to a misdemeanor. That is 25 MM 158.
You got that, Madam Clerk? Okay.
We stipulate to this court's jurisdiction to handle a misdemeanor. The agreement that's been reached is for Mr. Hendricks to admit to the VOP, which is being supervised by JCS, reinstate probation to complete original requirements and modify to include an additional 40 hours of community service work. There's a $100 VOP fee and a $150 cost of defense. And there's in 25 MM 158, that is a plea of no contest as charged to 1 count of possession of marijuana under 20 grams, a first-degree misdemeanor. That is pled as charged for an adjudication of guilt of $270 in cost and a $50 cost of defense. We would ask that those amounts be assessed in the probation case. May I approach?
Granted. All right, so be clear, the misdemeanor costs will be assessed in this case.
Right.
Okay. All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
And Judge, all these are misdemeanors.
Right.
Okay.
But,
You're good.
okay. Right, yeah, so we got to be clear about that.
Yeah.
He's pleading to the misdemeanor in the felony case, and in the new charges, those additional costs will be paid through his probation in his plea to in the felony cases, cases. Okay, all right. All right, you heard what Mr. McKinney said, and you signed the written plea form. Now, you got two things going on here. One is the new charge that you're pleading to today.
Yes, sir.
And the others are your violations of probation.
Yes, sir.
Okay? As to your violations, do you understand you're admitting the violations?
Yes, sir.
And you're waiving your right to a hearing where the state would have to prove that?
Yes, sir.
As to your new charges, do you understand you're pleading no contest?
Yes, sir.
Which says to me you believe the state could prove your guilt and you're not going to contest that.
Yes, sir.
And by making that plea, you're waiving your right to a trial where the state would have to prove your guilt.
Yes, sir.
All right. And you would be adjudicated guilty. And in your new charge, it's just the payment of the costs, and you'll have to pay those costs in your probation in the cases here.
Yes, sir.
Okay? And you'll have some additional costs which will be imposed in your reinstatement of your probation with JCS in these cases, which is the $100 and the $150, and you'll have an additional 40 hours of community service that you'll have to perform.
Yes,
Is that what you understood?
Yes, sir.
And Mr. McKinney answered all your questions about the plea and how it affects you,
Yes, sir.
and you satisfied with how he's represented you?
Yes, sir.
Okay, I'll find the plea to be freely and voluntarily entered into and accept the plea. All right. Be sure to report to JCS ASAP, okay?
Yes, sir. As soon as
All
I
right.
leave here.
All right, thank you now.
Just in case you need to report to them. Yes, sir.
Next is Dennis Kendall.
Hey there. Just do your background. Do you have any questions for me? Jason McKinney on behalf of Dennis Kendall, 18 CF 783. We've reached an agreement with the state on this felony violation of probation. Judge, Mr. Kendall wishes to admit the violation of probation 18 CF 783. The agreement that's been reached with the state is for an adjudication of guilt, 90 days in the Okaloosa County Jail with credit for time served, revoke and terminate his probation, $100 VOP fee, $150 cost of defense. We would ask for 1 year for Mr. Kendall to pay off those amounts. May I approach?
Granted.
This is a guideline sentence.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
All right, and you understand that you're admitting the violation?
Yes, sir.
And it says to me, Judge, I violated just the way the affidavit report says I did.
Yes, sir.
And do you understand by doing this, you're waiving your right to a trial where the state would have to prove you violated?
Yes, sir.
In this case, you be adjudicated guilty, sentenced to 90 days in the county jail, credit for time served. Your probation is going to be revoked and terminated, and you'll have the additional fees and costs that were talked about imposed on you.
Yes, sir.
Okay? And you've got some other outstanding fees and costs as well. How much time do you need to get all that paid off once you get out?
250, about 6 plus 600, that's a good bit.
About 6 months.
No, as for you.
Ask for a realistic amount of time. I mean,
A year.
yeah, a year to pay is fine. You know, the goal here is to give you the room that you need to get it paid, because I want you to get it paid off. I don't want it to hang around and haunt you forever, right? Get it paid off, get that wiped off so you can move on. That's the goal.
Okay.
Do you think that's realistic for you?
Yes, sir.
Okay. All right. Now, with that, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
And he's satisfied with what he's done for you?
Yes, sir.
Court find the plea to be freely and voluntarily entered into and accept the plea. We'll still need a score sheet, though.
Yes, sir, I believe the state's working on one.
Okay, very good.
Yes, sir.
This is Thomas Baronga.
Judge, this is Thomas Bergona before the court. He's here today in 24 CF 397, which is a felony violation of probation. He also has 25 CF 778, which is set for arraignment on the 22nd of May. And he also has a misdemeanor that's set for the 12th of May. Mr. Bergona is on the radar for drug court. I believe that Ms. Henderson's going to be meeting with him next week. And he may be observing as quickly as next week. So I would like to enter a denial to the violation today, and I'd like to track with 25 CF 778.
State?
There's no objection to that, Your Honor.
Okay, so ordered.
Jason McKinney for Aaron Weigel, 24 CF 315. Do you have any questions for me? We have reached an agreement in this violation of probation. The agreement that's been reached is for an admission to the violation of probation. An adjudication of guilt, he was previously adjudicated. 11 months, 29 days, Okaloosa County Jail with credit for time served. That will revoke and terminate his probation. There is a $100 VOP fee, a $150 cost of defense. There is $58.05 cost of transportation to Santa Rosa County. And to that, I believe that he was sentenced in Santa Rosa County on the 10th of March. So we would ask for the credit for those few days that he spent waiting on just this warrant coming over.
Granted.
May I approach with the agreement signed by all parties in the score sheet?
Granted. Raise your right hand for me, please. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, you can put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes, Your Honor.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
And that says, Judge, I violated just the way the affidavit report says I did.
Thank you, Your Honor.
Is that what you're saying to
Yes,
me?
sir.
And do you understand by doing that, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
In this case, you're sentenced to 11 months, 29 days county jail, credit for time served. Your probation will be revoked and terminated. You'll have the fees and costs that were announced. How much time do you believe is necessary for you to get all your fees and costs paid once you're released?
A year or two, sir.
A year? Okay.
Yes, sir.
I think that's realistic. I think that's realistic.
Yes, sir.
Okay. Mr. McKinney answered all your questions about the plea and how it affects you?
I'm sorry?
Has Mr. McKinney answered all your questions about the plea and how it affects
Yes,
you?
Your Honor.
And are you satisfied with how he's represented
Yes,
you?
Your Honor.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Jason Wilson?
Judge, this is Jason Wilson. Mr. Wilson is approaching in 23 CF 2173. And he's previously signed an agreement in this matter for the violation of probation. The agreement calls for an adjudication of guilt, 60 days in the Okaloosa County Jail with credit for time served, revoke and terminate his supervision with $100 VOP fee and $150 cost of defense. May I approach?
Please silence your phones.
I'm sorry, say that again. Talk to the judge. May I approach with that plea agreement?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Absolutely, yes, sir, Your Honor.
Okay, and you can put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes, sir, I did.
All right.
Judge,
Do
was
you-
that plea form signed by the state?
Yes.
Just wanted to make sure.
Thank you, Mr. McKinney.
Yeah.
Do you understand by this plea arrangement that you're admitting the violation
Yes, sir.
and waiving your right to a hearing
Yes, sir.
where the state would have to prove you violated?
Absolutely, yes, sir.
In this case, your probation is going to be revoked and terminated. You'll have some fees and costs to pay. You're going to serve 60 days in the county jail, credit for time served. About how much time do you think you'll need to get all your fees and costs paid after you get out?
I'm signing up for the driver's license clinic so I can get all of them and get my license in an orderly fashion because I've got a year.
A year? Okay.
Yes, sir.
And when you go to the clinic, if you tell them that you've got that year, they may be able to work with you on that with other stuff as well. But that'll give you some breathing room to take care of that, okay? With that, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with what he's done for you? Court will find the plea to be freely and voluntarily entered into and accept the plea. Oops, sorry. We've got, I guess, Mr. Corbett, who's supposed to be appearing remotely if the jail's ready.
Your Honor, my 1:30 arraignment out of custody, all three of them are here, and I was going to ask if the court would let me in and out of please quickly for them to sit through a potential legal pre-trial.
Okay, that's be fine. And then after that, I'm going to take after we get Mr. Corbett and do that, I'm going to take a brief comfort break before we get started.
Yes, sir.
Go ahead, Mr. Carnes.
Oh, I'm sorry.
That's okay.
I was like looking at the screen. First I have, Your Honor, be Alyssa Malamud. And Ms. Malamud is present. This is the case that we're going to be withdrawing from, and I already texted Ms. Jaquit and explained this to Ms. Malamud. But today, in 25 CF 583, we will acknowledge receipt of a one-count information, waive the formal reading, enter a not guilty plea, and we'll just ask that this remain on the May 12th docket so she can make contact with Ms. Jaquit.
Okay.
Okay? All right, so we'll be back in court on May 12th. Okay, 9 o'clock. All right. Next, I have Dean Merrifield. And Mr. Merrifield is present and approaching. We do have receipt of a one-count information. We will waive the formal reading, enter a not guilty plea. This is already on the July 14th docket. I talked to Mr. Gomez. There's going to most likely be a PTI offer here. I've talked to Mr. Merrifield. I believe that'll be acceptable, certainly. So if we could leave him on the July 14th docket.
So ordered.
All right. And then last I have is Cheryl Oglesby. And Your Honor, as she's approaching, I can tell the court, the first thing she told me is, I can't figure out how to turn off my phones. So,
Yeah, well, I had to have my daughter explain it to me too, so. I got the instructions now. And you saw what I did the first thing when I heard yours go off. I checked to be sure mine was.
It's natural, I do the same thing. We do have a two-count information. We will waive the formal reading into a not guilty plea. She's also on the July 14th docket, if we can just leave it on that docket.
All right.
Thank you, Judge.
All right, thank you.
Make sure you.
I'll be here.
All right. So who else is in the gallery for the 1:30 already? Is anybody else here for 1:30?
That's Mr. Tribble.
Tribble? All right, let's just go ahead and get whoever, if anybody else walks in after that, we're going to let them sit. But whoever's here already for 1:30, let's go ahead and take care of them and get them on. Come on down, line up. Let's take care of you before I take my comfort break.
Mr. Tribble is here in 25 CF 567. We're going to acknowledge the receipt of one-count information, waive its formal reading, enter a plea of not guilty, and ask for this to remain on the July 14th pretrial docket.
So ordered.
Thank you. Judges, are present matters.
Yes, your name is?
Victor Robinson.
All right. And Mr. Robinson, here today without an attorney. Do you want an attorney to represent you?
Yes, sir.
Have you completed the application for the appointment?
Yes, sir.
Okay. Let me have that. Let's take a peek. And is that what you take home every week, or does it vary?
Fairly.
Okay. Are you responsible for your own taxes, or do they take them out?
I'm responsible for my own, pretty much.
Okay. And is that after your taxes, or is that before your taxes?
That'll be before.
Okay. So if I were to take about 10% off of there, that would be about right after your taxes,
Yes,
you
sir.
think?
Yes, sir.
Okay. Okay. And you're not responsible for the support of anybody else other than yourself?
No dependents, no, sir.
Okay. Who paid your bond? You didn't check that part.
My mother.
Your mother, okay. And, okay. It looks like you do qualify. I'll give this to the clerk. The clerk will review it. If the clerk says you don't qualify, they'll tell you why. If you think the clerk is wrong, get everything you have that shows the clerk is wrong, give it to your lawyer and bring it to court with you next time, okay?
Yes, you are now being appointed to Mr. Robinson's case. We're going to enter not guilty to both counts, waive formal reading, and request to be kept on the May 12th pretrial docket.
Except for the July 14th.
July 14th?
Right.
That's right. Thank you.
So ordered. Now get in touch with Mr. Koch, and he'll help you navigate this case, okay?
Yes, sir, I appreciate it.
All right, thank you. All right, who else is in the gallery for the 1:30?
Thank you so much.
And what's your name?
John Robinson.
All right, you're here today without a lawyer. Do you want a lawyer to help you?
Yes, sir.
Have you completed the application?
No, sir.
Okay, complete that application, hand it to the bailiff, don't leave until you turn it in and get a new court date, okay? All right, and with that, we're gonna take 10 minutes.
Judge, can I approach real quick?
Yes.
So I'm not on a case.